Lovely. Thank you everybody for joining today's meeting. आज की मीटिंग में शामिल होने के लिए मैं पहले सबको शुक्रिया कहना चाहूंगी। आज हम एक बहुत इम्पोर्टेंट विषय पर चर्चा करने वाले हैं। हाल ही में जो दिल्ली राइट्स कॉन्स्पिरेसी केस में बेल रिजेक्शन के ऑर्डर्स दिल्ली हाई कोर्ट द्वारा आए हैं, उसको लेके एक पब्लिक डिबेट हो रहा है। हम देख रहे हैं कि बहुत लोगों ने एक निराशा व्यक्त की है। बहुत सारे ग्रुप्स बाहर आए हैं और ये बेल ऑर्डर का मतलब क्या है, इसका इम्पैक्ट क्या होने वाला है, इन सब चीजों के बारे में डिस्कशन आज पब्लिक डोमेन में हो रही है। तो आज इसी चर्चा में शामिल होने के लिए, इस डिस्कशन को आगे लेने के लिए पीपल्स यूनियन फॉर सिविल लिबर्टीज ने मीटिंग ऑर्गेनाइज की है और इसमें हमने एक अलग एमिनेंट एक्टिविस्ट लॉयर्स को भी शामिल किया है, तो जो इस विषय के बारे में चर्चा करेंगे। हमसे इन ऑर्डर की अलग अलग पहलू के बारे में चर्चा करेंगे और साथ ही में इसका बड़ा जो एक ये क्या एक मैसेज पास कर रही है हम सबको, इससे हमें क्यों इसके बारे में हमें क्यों सोचना जरूरी है और ये क्रिमिनल जस्टिस सिस्टम में जो इश्यूज है उसको कैसे एक्सपोज कर रहा है, इन सब चीजों के बारे में आज हमें चर्चा करने का मौका मिलेगा। I would like to invite, I would like to express my gratitude to all of you for joining us for this meeting. People's Union for Civil Liberties, felt the need to organize this meeting after the recent orders passed by the Delhi High Court in the Delhi riots conspiracy case, rejecting bail of 10 of the accused activists. We've recently seen that there's been a lot of public debate around this. And in order to join this conversation, also to invite human rights defenders, to invite lawyers who have been discussing this, who have been conversing about this in the public domain. We felt that this platform was necessary to provide that opportunity and also to discuss how we can take the larger issues that that come into the fore because of these orders, whether it is what's ailing the criminal justice system, whether it is the judicial mindset in cases against human rights defenders, whether it is this very case of Delhi riots conspiracy that was created. These issues have become very important for all of us to discuss and take forward. And this is one opportunity that we presented with to do that. Without losing more time, I would like to start inviting the speakers. But before that, there's a request to try and speak in both Hindi and English, or if anyone requires a translation, if any of the speakers choose to go with one language, you can let us know in the chat box and we can try and give a quick translation if possible, either as a summation at the end of the address or probably also on chat. So this with this, we'd like to start start to introduce today's speakers. First, we have Nadim Khan, National Secretary of the Association for Protection of Civil Rights, and a committed human rights activist who has been supporting those who have been accused in the Delhi riots conspiracy case through campaigns and through legal process. Also, who has been raising these questions in public domain and following the case. To first tell us more about the cases, about these orders, and also the persons who have been incarcerated for a period of over 5 years now in these cases. पहले मैं नदीम खान जी को इनवाइट करना चाहूंगी, जो एसोसिएशन फॉर प्रोटेक्शन ऑफ सिविल राइट्स के नेशनल सेक्रेटरी है और कार्यकर्ता है, जो इन केसेस को लेके कैंपेन कर रहे हैं बहुत समय से। और मैं उनको न्योता देना चाहूंगी कि पहले वो हमें ये केस क्या है और जो आज जेल में है, जिनको बेल डिनाई किया गया है, उनके बारे में थोड़ा हमें बताने के लिए मैं उन्हें आग्रह करूंगी। नदीम खान जी, इफ यू कैन स्टार्ट।
शुक्रिया, थैंक यू वेरी मच लारा फॉर ऑर्गेनाइजिंग दिस मीटिंग। हम सब बहुत ज़्यादा डिसअपॉइंटेड हैं कोर्ट से और इस ऑर्डर से भी, और बहुत कुछ नया बताने के लिए नहीं है। जो लॉयर्स हैं इस पे वो बात अपनी ज़्यादा बेहतर रखेंगे इन कंपैरिजन टू पीपल लाइक अस दोज हु आर ग्राउंड एक्टिविस्ट। लेकिन हम सब को जो जब ये केस 2022 में व्हेन दे came from lower court to high court, then we have a lot of expectation. But ये जो पूरा केस है अपने आप में मॉकरी ऑफ जस्टिस किस हिसाब से है कि पहले ये एक स्पेशल केस हम सब के लिए रहा कि इस केस को कैसे लिंगर ऑन किया गया। एक जज जो इस केस में इस पर्टिकुलर 59/2020 में तीन लोगों को बेल देते हैं, वही जज बाद में उसी केस में को एक्यूज जब दोबारा आते हैं बेल के लिए तो उनसे एक बेसिक सवाल वो क्रिएट करते हैं कि वो को एक्यूज जिसपे वो केस को बेल दे चुके हैं, जिस जिस केस पे जस्टिस बम्बानी के साथ में वो जज तीनों एक्यूज को बेल देने के साथ साथ पुलिस की इन्वेस्टिगेशन को चैलेंज करते हैं, पुलिस के इन्वेस्टिगेशन पे सवाल उठाते हैं और यहां तक वो जाते हैं कि वो इन्वेस्टिगेशन एजेंसी के रहने पर और यूएपीए के रहने पर भी सवाल करते हैं। फिर वही जज जस्टिस सिद्धार्थ मृदुल जब दूसरा एक्यूज उनसे बेल लेने के लिए हाई कोर्ट में पहुंचता है तब वो कहते हैं कि इनकलाब जिंदाबाद के नारे क्यों कोर्ट में लगाए गए, क्यों सड़कों में प्रोटेस्ट में लगाए गए। तो अब उस इस केस में जो सुनवाइयों का प्रोसेस हुआ है उसके हिसाब से अगर देखा जाए तो इनकलाब जिंदाबाद का नारा भी अपने आप में एक सिडिशियस नारा है और उसके हिसाब से इस पे कार्रवाई होनी चाहिए। फिर जिस तरह से दूसरे लोग जब इस बेल के लिए पहुंचे तो किस तरीके से उस ऑर्डर को रिजर्व ऑर्डर किया गया और जज साहब जो है वो मणिपुर के चीफ जस्टिस बन गए। फिर हमने देखा कि दूसरे जज पहुंचे वहां पर जस्टिस केत और उन्होंने उस ऑर्डर को रिजर्व किया और उस ऑर्डर को रिजर्व करने के बाद वो मध्य प्रदेश के जब चीफ जस्टिस बनकर पहुंचे तो वहां पर जब उनसे जबलपुर हाई कोर्ट में जर्नलिस्ट ने पूछा कि आपने इन इन लोगों की सुनवाई करी थी, 59 के अक्यूज के नाम लिए, तो उन्होंने कहा मुझे याद नहीं पड़ता है। और वो हियरिंग मोर देन 1.5 years जस्टिस केत के पास चली थी और तब उसमें नई बेंच बनी उसके बाद तो 1 साल से ज्यादा सुनवाई करने के बाद जस्टिस केत का ये रिप्लाई था कि मुझे याद नहीं है कि मैंने ये सुनवाई करी है कि नहीं करी है। और फिर जब हमने अभी ये इस हाई कोर्ट के जजमेंट को देखा तो हमें ये अंदाजा हुआ कि ये जो जजमेंट है, हम सब पहले ये मान के चलते थे कि पुलिस का और सिस्टम का प्रेशर बहुत ज्यादा लोअर कोर्ट्स में होता है तो यूएपीए के मैटर में लोअर कोर्ट्स कभी भी जो है वो बेल के ऑर्डर नहीं दे पाती, वो इतनी पावर नहीं होती हैं। लेकिन हाई कोर्ट के इस ऑर्डर को देखने के बाद ये एहसास होता है कि जुडिशरी का लेवल 2014 से 2025 में इस लेवल पर आया है कि हाई कोर्ट वो भी अब लोअर कोर्ट से ज्यादा डिग्रेडेड हो गए हैं और उनमें भी लग रहा है कि ऑर्डर कहीं से डिक्टेट हो रहे हैं। अब अगर हम बात करें यूएपीए की या यूएपीए के इस ऑर्डर पे तो जो लॉयर्स हैं वो ज्यादा बात रखेंगे। जैसे उमर खालिद को 13 सितंबर 2002 में अरेस्ट किया गया और उनके ऊपर एफआईआर 59 थी और एफआईआर 101 थी। 101 में बेल मिल गई, क्लियरेंस हो गया, लेकिन 59 की वजह से वो अटके हुए हैं और ये शायद अंदाजा दिल्ली पुलिस को भी था कि दूसरे केसेस में यूएपीए अगर नहीं लगा होगा तो सबको बहुत आसानी से बेल मिल जाएगी। इस पूरे केसेस में जिस तरह से प्रोटेक्टेड विटनेस का एक नेटवर्क और प्रेशर विटनेसेस का जो नेटवर्क बिल्ड किया गया है उसमें आपको खुद याद होगा कि उमर खालिद के एक दोस्त जिनका मैं नाम नहीं लूंगा, आपको आसानी से ये खबरों में मिल जाएगा कि जब वो पुलिस की इंट्रोगेशन के बाद व्हेन ही केम बैक तब उन्होंने ये बात कही थी कि मुझ पर प्रेशर डाला गया कि मैं उमर खालिद के खिलाफ गवाही दूं। और ये बात उन्होंने मीडिया से कही और उसको फिर उमर के वकीलों ने कोर्ट में भी अप्रोच किया। तो इससे ये साबित होता है कि ये बात हमको समझ में आई उनके कहने पर, लेकिन जो प्रोटेक्टेड विटनेस बनाए गए हैं या जो विटनेसेस लिए गए हैं, वो विटनेसेस किस तरह से लिए गए होंगे। उसके बाद गुलफिशा फातिमा पर एक का अरेस्ट 9 अप्रैल 2020 में हुआ। उनके ऊपर एफआईआर 59 है और उनके ऊपर एफआईआर 48 है। तो एफआईआर 48 में उनको बेल मिल गई है, उनको भी सिर्फ रुकी हुई है वो 59 के लिए। शर्जील इमाम का केस और क्लासिकल एग्जाम्पल है कि 28 जनवरी 2020 में शर्जील इमाम जो है अरेस्ट होते हैं, 8 केसेस लगते हैं उनको, बाकी सब में बेल मिल जाती है। और उस केस में वो जेल में हैं। जो केस जो इंसिडेंट उनके जेल जाने से 2 महीने बाद होता है, जो इंसिडेंट उनके जेल जाने से जो जिस कम्युनल वायलेंस का केस बिल्डअप करके उनको जेल भेजा गया, वो केस उनके जेल जाने से 2 महीने बाद होता है, उसके लिए वो जेल में है। बाकी जो उन पे ऊपर 8 केसेस थे उसमें उनको बेल मिली हुई है। खालिद सैफी के ऊपर 3 केसेस हैं। 26 फरवरी में उनको अरेस्ट किया गया और कस्टोडियल टॉर्चर हुआ। खालिद फरवरी सैफी 26 फरवरी 2002 में अरेस्ट हुए और उनके ऊपर जो केसेस हैं वो एफआईआर 44 है, एफआईआर 59 यूएपीए वाली है और एफआईआर 101 है। देन अगेन द सेम थिंग इज हैपनिंग एट हियर कि 44 में उनको बेल मिल गई है, 101 में उनको बेल मिल गई है और उनको जो अभी वो जेल में है सिर्फ 59 की वजह से, यानी कि यूएपीए अगर नहीं लगता तो बाकी केसेस में जिस तरह से उनको बेल मिलती। मिरान हैदर जामिया के स्टूडेंट लीडर थे, उनको 1 अप्रैल 2020 में अरेस्ट किया गया। कोविड टाइम में सिर्फ एक केस है 59 और जिसमें उनको बेल नहीं मिली है। उसके अलावा शिफाउर रहमान को 26 अप्रैल को अरेस्ट किया गया। उनके ऊपर भी सिर्फ एक केस है यूएपीए का 59 और अभी भी वो जेल में है। अतहर खान 2 जुलाई 2 जुलाई 2020 में अरेस्ट हुए। उनके ऊपर 59 है, 60 है और 163 है, यानी कि 3 केसेस हैं, 59, 2020 एंड एफआईआर नंबर 60, 2020। तो उनको भी इन दोनों केसेस में इमीडिएट विद इन अ ईयर बेल मिल गई थी। फिर उसके बाद मोहम्मद सलीम खान है। सलीम खान को 11 मार्च 2020 में अरेस्ट किया गया। उनके ऊपर एफआईआर 163 है इस यूएपीए 59 के इंस्टीड ऑफ दिस 59, 60 है और 163 है। उनको भी जो है वो दोनों एफआईआर में 163 और 60 में बेल मिल गई है। शादाब अहमद जो कि प्रोटेस्ट में एक्टिव थे ट्रांस यमुना के इलाके में, शादाब अहमद को अरेस्ट किया गया 6 अप्रैल 2020 में और उनके खिलाफ 2 एफआईआर हैं, 59 एंड 60। तो उनको भी 60 में बेल मिल गई है, 50 की वजह से वो जेल में है। जिस दिन ये ऑर्डर आया नवी जस्टिस नवीन चावला की तरफ से, उसी दिन एक ऑर्डर और आया। वो सिंगल ऑर्डर था तस्लीम अहमद का। तस्लीम अहमद को 19 जून 2020 में अरेस्ट किया गया था और तस्लीम अहमद के ऊपर 2 केसेस हैं, एफआईआर 48 और एफआईआर 2020। एफआईआर 2020 में उनको 48 में उनको बेल मिल गई है, 59 की वजह से वो जेल में है। उसके अलावा एक सलीम मलिक और सलीम मलिक मुन्ना है। देयर इज अ टू सलीम, वन इज अ सलीम खान, अनदर वन इज सलीम मुन्ना। सलीम मलिक और सलीम मुन्ना के ऊपर 2 एफआईआर हैं, 3 एफआईआर हैं, एक 59, एक 60 और एक 136। 136 में विद इन 6 मंथ्स he have got the bail, 60 में विद इन 8 मंथ्स he have got the bail, 59 में वो अभी भी जेल में है। ताहिर हुसैन के ऊपर इस पूरे प्रोसेस में सबसे ज्यादा एफआईआर हैं। ताहिर हुसैन के ऊपर 12 केसेस हैं। 11 ऑफ देम द क्रिमिनल केसेस, वन इज द इन्फोर्समेंट डायरेक्टरेट का केस है। 11 केसेस में उनको जो बेल है वो 11 केसेस में उनको 10 केसेस में बेल मिल चुकी है, सिर्फ वो जेल में यूएपीए की वजह से हैं। तो इस पूरे प्रोसेस में एफआईआर 59 के केसेस को जब हम देखते हैं तो ये मालूम चलता है कि जिन जिन सेक्शंस में लोगों को अरेस्ट किया गया उनको विद इन अ मंथ, विद इन अ 2 मंथ्स, मैक्सिमम विद इन अ 3 मंथ्स उनको बेल मिल गई। हालांकि कुछ लोगों को, जैसे मैंने लास्ट नेम लिया सलीम खान और मुन्ना को, उनकी लास्ट जो बेल है दूसरे केसेस में, उनको बेल जुलाई में हुई और उनको 59 में री अरेस्ट किया गया समवेयर इन आई थिंक 26 जून के आसपास में। तो इस तरह से पूरा प्रोसेस किया गया। अब बाकी ये केस इतना ज्यादा डिस्कस किया जा चुका है कि अब जुडिशरी के रोल पर ही डिस्कशन बचता है। बाकी मुसलमानों को मुसलमानों ने मारा, और मुसलमान मुसलमान को मार रहा है, और वो कम्युनल वायलेंस भी है। और कम्युनल वायलेंस के केस में मुसलमान को उसकी कॉन्स्पिरेसी में अंदर है। और फिर ये पहला केस अपने आप में है जिसमें मैक्सिमम मुसलमान मारे गए। मुसलमान मुसलमानों को ही मार रहे हैं आपके हिसाब से। एंड देन द सेकेंड थिंग इज दैट कि नैरेटिव आपने ये सेट कर दिया कि जो है वो ये वायलेंस पूरा एंटी हिंदू वायलेंस था। मुसलमान मुसलमान को मार रहा है, मुसलमान ही मर रहे हैं, लेकिन वायलेंस एंटी हिंदू वायलेंस है, जिसके तहत जो है वो किसी को बेल नहीं मिलेगी। फिर ओवरऑल अगर देखा जाए तो अब जो मीडिया काउंटर नैरेटिव सेट कर रहा है, वो आपने भी देखा होगा कि वो काउंटर नैरेटिव सेट किया जा रहा है सुप्रीम कोर्ट में। जजेस ने जो है वो बेंच किसकी थी और कैसी थी ये सबको मालूम है। उसके बाद उसमें एडजमेंट ले लिया गया, लेकिन उसमें एक बात मैं इस केस के अलावा है, लेकिन मैं उसी काउंटर नैरेटिव पे एक बात कह के अपनी बात खत्म करूंगा, क्योंकि मेरे लिए बहुत ज्यादा कहने की इसमें बात नहीं है। जब बेला त्रिवेदी के पास ये केस पंच हुआ जिसमें उमर खालिद की जब बेल अप्लाई हुई थी, तो उन्होंने उस समय उनके वकील कपिल सिब्बल साहब ने यूएपीए को भी चैलेंज किया था। तो वो ऑटोमेटिकली जब बेला त्रिवेदी के पास गया और इन्होंने विड्रॉ कर लिया, तो उस समय त्रिपुरा में जो फैक्ट फाइंडिंग टीम लॉयर्स की गई थी, वो केस भी उसी के साथ एड ऑन हो गया था, और 120 का केस भी उसी के साथ एड ऑन हो गया था। तो जब उमर खालिद का केस विड्रॉ हो गया और उमर खालिद की बेल रिजेक्शन का सौभाग्य बेला त्रिवेदी को नहीं प्राप्त हुआ, तो उन्होंने फिर उन 120 बच्चों की जिनको ट्विटर पर ट्वीट करने के लिए अबाउट द त्रिपुरा वायलेंस उनके ऊपर यूएपीए का एफआईआर हो रहा था, उनको दोबारा से नोटिफाई किया। तो आप ये अंदाजा लगाएं कि जिस केस में उनका कोई रोल नहीं था, जिस केस में उनसे कोई डिमांड करने नहीं गया था, उन्होंने री नोटिफाई किया उस केस को। तो जिस केस में आप अगर उमर खालिद के केस में बेला त्रिवेदी के पास कोई बेल लेने जाता, तो 2002 के कम्युनल वायलेंस की लॉ सेक्रेटरी उसको कैसे बेल देती, ये सोचने वाली बात है। असल जो डिस्कशन इसकी बात है, वो बात है डिग्रेडेशन ऑफ द जुडिशरी। पहले हम ये मान के चलते थे कि यूएपीए में लोअर जुडिश कोर्ट से कोई भी हमें एक्सपेक्टेशन नहीं है, लेकिन अब बहुत डिसअपॉइंटमेंट के साथ हमें ये कहना पड़ रहा है कि अब उस कैटेगरी में हाई कोर्ट भी आ गए हैं। और जिस तरह से ये ऑर्डर हमारे सामने आया है, तो हम लोगों को तो ये एहसास हो रहा है कि बाबरी मस्जिद के टाइम पे ये कहा गया था जजमेंट में कि ये ऑर्डर कहीं और से लिख कर आया है और उसको प्रोनाउंस किया गया है। अभी भी हमको ये कहने में कोई हिचक नहीं हो रही है कि इन ऑर्डर और उन आर्ग्यूमेंट्स को देखने के बाद हमें ये महसूस हो रहा है कि ये ऑर्डर सॉलिसिटर जनरल तुषार मेहता के ऑफिस से लिख कर आया है। थैंक यू वेरी मच। आई डोंट हैव एनीथिंग मोर टू से।
Thank you, Nadeem. Very strong words and very important information on the case. In a nutshell, Nadeem also pointed out how the UAPA had been weaponized in order to ensure that those who were arrested could not secure bail, and to make it hard for them to, get bail. And this is also one of the reasons for the prolonged incarceration. One of the other very important points I think Nadeem, communicated was the disappointment that we all feel today. We said that from the lower judiciary, one had expected over a period of time to not be able to secure reliefs, but now we are seeing that even the higher judiciary is, passing similar orders. He went on to say that the order is. It's appears to be entirely coming in from the offices rather than from the judiciary's own mind. So I think this is a very important, some very important points that Nadim raised. If we need a more, a more detailed translation, we can provide it on the chat. But Nadim said that this order has actually really brought out very severe problems that we are facing today. We're seeing today with the criminal justice system, with how the judiciary is looking at the right to bail, with how the judiciary is treating political prisoners, and with also how, the conspiracy today here, also of framing those who had been involved in the anti-CA protests, or to framing Muslims when Muslims itself were the victims of the pogrom that was conducted in Delhi. Um, how the judiciary has enabled this in different ways. It's a very important discussion that we need to have. And that takes us to the next speaker, Advocate Shahrukh Alam, who practices in the Supreme Court, and will be talking to us about the prosecution case and the long wait for these orders, the long wait for bail. इस जो नदीम ने आज जो अभी जो हमें केस के बारे में बताया, अलग अलग पहलू के बारे में बताया, साथ ही में जिन लोगों के ऊपर आज केसेस है उसके बारे में भी हमें जानकारी दी, उसमें उन्होंने एक बहुत इम्पोर्टेंट पॉइंट जो रेस किया कि ये केस जो है ये बहुत सारे इश्यूज को अभी ओपन अप कर लेता है, कि ये जुडिशरी का रोल क्या है आज ऐसे केसेस में जहाँ पे बेल डिनाई किया जाता है, यूएपीए का इस्तेमाल किया जाता है, इसका मतलब क्या है, ये प्रोसिक्यूशन केस जो आज हम लोग जो बनाया गया है उसको उसकी मदद करने में जुडिशरी का क्या रोल रहा है। तो ये हमें हमारे अगले स्पीकर के तरफ भी लेके जाता है, जो एडवोकेट शाहरुख आलम है। वो हमें ये प्रोसिक्यूशन केस के बारे में थोड़ी जानकारी देंगे और थोड़ा ये भी बताने की कोशिश करेंगे कि इतना टाइम क्यों लगा है ये ऑर्डर्स आने के लिए। वो भी हमें पता है नेगेटिव ऑर्डर्स आए हैं, लेकिन ये बेल के राइट को मिलने के लिए इतना टाइम क्यों लग रहा है, इसके बारे में भी वो हमें बताने की कोशिश करेंगे। शाहरुख, प्लीज गो अहेड।
थैंक यू लारा, थैंक यू। अगर इस बात का जवाब हम दे सकते कि इतना वक्त नहीं लग रहा है।
Shahrukh, there's a lot of echo. Please, your audio has to be clearer.
You tell me, can you hear me?
Is she audible to all?
Am I audible?
Actually, we can hear you. You can go ahead, Shahrukh.
Yeah.
Right, thank you, thank you. You know, ever since the order came, I've been trying to think about it on different registers. Is there any register, the register of law, your history, your politics, that will help me make sense of it? And there's only the register of cynicism and despair that actually answers any of the questions about the order. You know, I believe that any state's commitment to rule of law can be gleaned by the way its prosecutors frame their cases. Jab case aata hai court mein, how do they frame their cases? How much social and political prejudice against the accused do they rely on to actually make their cases? When is it that the Solicitor General of a country says in court that let him stay in jail until the time that he's acquitted or convicted? If there is a suspicion against X-accused, let him stay in jail. And then the fidelity of the courts to the rule of law can be gleaned by how much space the courts give to Solicitor Generals who make this kind of arguments in court. Why did the court not tell him to not make such absurd arguments? The government also goes on about decolonization of the law. इसको decolonize कर रहे हैं, वक्त को decolonize कर रहे हैं, criminal law को decolonize कर रहे हैं. But when I read about the arguments that were made in court during the bail hearings, the first thing that I was reminded of was the trial of Bahadur Shah Zafar. उसमें एक मेजर हैरियट थे जो स्टेट की तरफ से बहस कर रहे थे, और जब सारी बहस हो गई उनकी, तो क्लोजिंग स्टेटमेंट था मेजर हैरियट का फॉर द स्टेट, फॉर द ब्रिटिश ईस्ट इंडिया कंपनी अगेंस्ट द एम्परर बहादुर शाह जफर। वो कहते हैं कि आई थिंक जेंटलमैन, even one must allow that if we had no other evidence of a plot, no testimony indicative of a previous conspiracy, the very nature of the outbreak itself must convince us of the existence of a plot. Does that sound familiar? कहते हैं एविडेंस नहीं है तो नहीं है, कोई टेस्टिमनी नहीं है, ठीक है, but the very fact that this happened must convince us of the evidence of a plot, and therefore let's hang the emperor. And then he says, I need not quote what may be the law of the land on such a point, because the law of our conscience and our sense is far greater. It does not depend upon local constitutions, upon human institutions or religious creeds. It is a law that we find in the heart of man. So these are the kind of arguments that they were making at that trial. And again, it rings familiar because it's not very different from the kind of arguments that the learned Solicitor General made before the court. And when the court gave him complete space and complete freedom to make these arguments. That's the register of history, where you see that history is repeating itself. Let's go on to the register of law. Let's just look at the case of the prosecution. Agar aap charge sheet padhein, it's a very peculiar, it's a very odd argument that the charge sheet is making. The charge sheet says that, in fact, these people, the conspirators, are diabolical. They have no interest in CAA. They have no interest in anything else. Their primary goal was to pick up any issue and create disruption, riots, public disorder, and threaten the unity and integrity of India. तो ये इनकी मंशा थी। अब ये कैसे करने वाले थे ये? वहां पे चार्जशीट ये कहती है कि they knew that if they hold public protests, somebody will get so annoyed that violence will get initiated. तो ये खुद नहीं करने वाले थे violence. All they had to do was hold public protests and know that some third party will get so annoyed that violence will ensue. Really, that's a very badly planned conspiracy, if there was such a conspiracy. Agar conspiracy karni thi, the more efficient way to do it would have been to actually cause violence yourself. But no, according to the charge sheet, इनको बस public protest करना था, कोई ना कोई उठेगा और violence करेगा. The problem there is that the conspiracy is that you'll provoke somebody into violence. You'll provoke people who are not opposed to the CAA into violence. But grave and sudden provocation in criminal law is a defense. You can't prosecute somebody for causing grave and sudden provocation such that the third party is causing violence. हम आपको एग्जाम्पल देते हैं, अगर हम लारा को इतना प्रोवोक करें कि लारा थप्पड़ मार दें हमको, then the law is that Lara will first be questioned. Lara will first be prosecuted for having hit me. And it will be Lara's defense कि भाई उन्होंने इतना ज़्यादा provoke किया हमको कि हम क्या करते हैं, मैं थप्पड़ मार दिया हमको. The law doesn't first prosecute me for being hit by Lara. तो इस केस में अगर आप कपिल मिश्रा को पकड़ के लाएं, अगर आप अनुराग ठाकुर को पकड़ के लाएं और आप कहें कि तुमने क्यों किया, were you responsible for the violence, then it will be Kapil Mishra's defense or it will be Anurag Thakur's defense to say that no, Umar Khalid and the rest of them caused so much grave and sudden prosecution by sitting on dharnas, by blocking public roads, that we had to do it. मगर यहाँ पे आप किसी को लाए नहीं हैं जो कह रहा है कि I have committed the violence out of provocation. तो फिर आप provocation का केस कैसे बना रहे हैं मेरे खिलाफ? That's the first point. Who got provoked by me? किसको हमने इतना provoke कर दिया? Right? The one thing that is conspicuously lacking throughout this long, detailed charge sheet is the name of the accused, even where it's known to the police. Okay, there's a series of FIRs across Northeast Delhi relating to different incidents of violence. तो इस particular violence में ये FIR है, इसमें ये accused है और ये victims हैं. The charge sheet में accused की list है, victims की भी बहुत ही truncated list है. Then how does the charge sheet make the nexus between the accused and the supposed conspirators? Who got provoked? And secondly, who got incited? अगर आप ये कह रहे हैं कि नहीं प्रोवोकेशन छोड़ दो, हमारी बहस ये है कि आपने इंसाइट किया लोगों, तो फिर उन लोगों को पेश करिए जो इंसाइट हुए मेरे भाषण से. किसको इंसाइट किया? गुलफिशा ने, शर्जील ने किसको इंसाइट किया? उमर खालिद ने किसको प्रोवोक किया? And unless you bring out the nexus between the accused people and the conspirators, how do we know that there was a nexus? How do we know that there was a causal chain? For all we know, these were completely extraneous to the alleged conspiracy. These were complete outsiders. How do we know that they were not people sent by the pro-CAA protesters? So it could very well be that even going with your argument that there was a conspiracy, did the conspiracy enact itself? Or did third-party extraneous elements come in and actually indulge in violence in parallel to your alleged conspiracy? Why are you not answering these questions? This prosecution case में इतने loopholes हैं कि you don't even have to look. You don't even have to go through the entire charge sheet. You read any 5 or 10 pages of the charge sheet, and it's full of very conspicuous lapses. And the court didn't need to work very hard. If the court looked, it would have found many reasons to grant bail. So I don't know why it didn't, why it couldn't bring itself to do that. The political register. Where does this leave us in terms of the political register? I've said this before on, I think, even PUCL platforms, that the amendment to the Citizenship Act sought to change the contours of citizenship for Muslim citizens of India. That suddenly you find that the contours have changed. You were very confident in your citizenship and not anymore. And I think that in the aftermath of the anti-CAA protests, even though the CAA was delayed a bit, the criminal justice system achieved exactly that. Through these series of cases, and particularly 59 of 2020, the state has managed to do exactly what the CAA intended to do. It has changed the contours of citizenship rights for Muslims. Because the case it is making is that Muslim mobilization is inherently dangerous to the unity and integrity of India. That Muslim mobilization is inherently a risky act. It's an act akin to noxious bodies being out on the street. And that is very problematic. And that is a political shift together with a legal shift. To criminalize political mobilization of Muslims as Muslims. And then last of all, the register of cynicism and despair. It's a difficult time for practitioners to see an inversion of law and then to have to go back to those courts to practice law, to make arguments that apparently have no space. But again, that is the only hope we have. That is the only skill we have. That is the only way that we know. So we will have to keep going back to the constitutional courts and make constitutional arguments. And at some point, they will start to make sense. Thank you.
Thank you so much, Shahrukh. I think you very beautifully articulated some concerns that all of us are feeling also as lawyers, the despair to go back to courts that are unyielding, and some very important points that have come in, and also comments that are coming in on chat on these points, which you can have a look at. I think there's no request for translation, so we'll continue in the English mode. If there are any translation requests, they can be put on the chat, and one of us will provide summary translations on chat. Some very important points have come through the earlier two speakers, Nadim and Shahrukh. And also, the crux of this case, what it brings up for all of us, which has been articulated by both the speakers earlier, is how Muslim mobilization, a political mobilization by Muslims as Muslims, has been criminalized in this case. We saw during the anti-CAA protests, which had resulted in a huge mobilization from the Muslim community, where citizens were out on the streets fighting for their citizenship, with the constitution in hand, with the national flag, with symbols of Indian citizenship on display, in a very peaceful manner that took place all across the country. It happened in our city. I come from Bombay, and we saw huge amounts of protests that took place here, and the discomfort with it that the state felt, we see in the way in which we've seen the backlash in the Delhi riots conspiracy case, and it's telling of the times. Because today, when we are seeing an increasing attack on Muslims, the attack is of a communal nature. It is targeting many social, economic, and civil and political rights of the people. And we are seeing it happen through the SIR. We are seeing it happen through the attacks on Bengali Muslims that are taking place in different cities. We are seeing it with the criminalization of Muslims, the hate crimes against Muslims. Also, at this time, what we're seeing is a reduction in the, in the political rights, the public space that Muslims can inhabit in order to protest against many of these actions, to take, to voice out their concerns as citizens. So again, we are talking about the shrinking of these very spaces, which are very important for Muslims to, to communicate their rights. And this Delhi riots conspiracy case also serves as an example of reprisals against human rights defenders who asserted their right to protest. This is a case of an attack on the right to protest itself, because at the fulcrum of the case, we see, the criminalization of that right, and that right itself, the exercise of that right itself, building the foundation for setting up this conspiracy case. So moving to some of our expert speakers now, we have with us Advocate Gautam Bhatia, who has been writing about this case. We've seen two recent articles that he's written on the bail orders that we all have, I think, we all have had the opportunity to read, and we'll also post the links here. Gautam is a Delhi-based lawyer and legal scholar. He has been following the 2020 Delhi riots conspiracy case since the beginning, and has been writing about it, and also has been, through his writings, raising very crucial points on why these bail rejection orders and the systematic bail rejections that we have seen over the last 5 years are, a matter of concern. Gautam, can I please invite you to unmute yourself and address the audience?
Yeah, thank you. I hope I'm audible and clear.
You are.
So, thank you. So thank you for inviting me. This is not the first time, I'm speaking at an event like this, and it's been 5 years, and this is the third rejection of bail. And each time you think that the next judgment whatever it says, it could not possibly be worse than the previous one, and yet somehow it is worse than the previous one. So I'll just sort of set out, and Shah Rukh's done a great job of setting out the prosecution's case. So what I'll do is I'll set out the legal landscape and then talk about what these bail judgments do and how they do it. So I mean, the first thing is that the reason why bail is so important is because criminal trials in India just take a very, very long time. And specifically these kinds of trials where you have 900 witnesses, the way our legal system works, these trials will take more than a decade. And so by the time that you end up with a legal verdict, it will be, you'll have spent a decade or more in jail. And so therefore, basically the only shot at liberty is being given bail by the court. Now, normally the standards for bail include the seriousness of the offense and the whether the accused is a flight risk or not, and finally whether the accused might tamper with the witnesses or not. So there are three requirements that the courts normally take into account. Now, the UAPA under Section 45 basically adds what is called the twin test, one prong of which is that if, in the opinion of the court, after perusing the police diary, it seems that there is a prima facie case against the accused, and I'm paraphrasing, then there is a statutory bar on granting bail. And of course, the point is that at this stage of bail, the defense has not had a chance to lead evidence or to cross-examine witnesses. So the only record that is with the court is the prosecution's record. So on that basis, it makes the determination. So that makes bail, even as a matter of statute, extremely hard under the UAPA. Now, courts have gone two ways with respect to this. One set of cases have taken what I call the eyes wide shut approach, which is spearheaded by this infamous Supreme Court case called Vatali, which basically says that the court's role is to just do a surface level, light touch examination of the evidence, and then, and just on that basis, decide the issue of prima facie case and therefore bail or not. And of course, if you were to apply the Vatali standard strictly, as a number of courts have done, it is virtually impossible to get bail. But other courts, other benches, having understood that this is really an unworkable standard, have actually said and have gone into the evidence and have granted bail, where it's very clear that the evidence has internal contradictions. It is not really strong evidence, and what seems to be happening is basically a frame up. And that you see actually very strongly in the bail order that granted bail to Natasha Narwal, Devangana Kalita, and Asif Iqbal Tana. That case did that, and of course, then the Supreme Court stayed that and said you can't use this as precedent. So that's another story. Now, in the cases of these activists and the cases rejecting bail, and the one I have studied most closely previously have been the two bail orders in Umar Khalid's case, but now of course you have a combined order. You see what is the extreme version of the eyes wide shut approach, because here not only is the court not giving the evidence any kind of serious scrutiny, but actually it is filling in the gap where there are gaps in the prosecution's case. It's the court that fills in those gaps and then uses that to deny bail. And let me explain how. What happens, of course, as you all know, in the FIR, is in relation to the 2020, communal violence in Delhi that led 54 people dead, most of whom were Muslims, and the nine individuals in this case are all individuals who were, protesting against the CAA and were involved in the organization of dissent against the CAA. Now, dissent and protest is a right. It's not criminal. And so what the prosecution needed to do was to establish some kind of a bridge between this protected activity of dissent and peaceful protest and the eventual violence. And the problem was that none of these individuals had ever actually incited violence or were ever on record inciting violence. And therefore, what the prosecution does is it says there is a conspiracy. Now, a conspiracy is something which is very easy to claim because by their very nature, conspiracies are secret. And so therefore, all you have to do is to say, look, because it was a conspiracy, you actually will not have public evidence of these people actually committing criminal offenses. It was all done in secret. Now, of course, you have to have some kind of evidence for the secret actions that were taken. So, what does the prosecution do? It basically brings forward what in law are called protected witnesses, which basically means anonymous witnesses, because the idea is that these witnesses, that is in theory, these witnesses might be subjected to threats or blackmail if they're were to be made public. So you have this whole range of anonymous witnesses who are given the most absurd names, Johnny and Bravo, all kinds of things, and the only real piece of evidence, direct of that kind, is that they say that I heard someone say, or I heard someone tell me that this person talked about overthrowing the government, or that this person was wanting to do violence. So even these protected witness statements are A, very vague, and B, really are not corroborated. So all you have basically is that. Now, it seems that even the courts feel like that was not enough. So what do the courts do then? The courts then pick up upon the most bizarre events to fill in these gaps in the prosecution's case. So, for example, and this for me really stands out as being particularly bizarre, is that the accused individuals, among other things, are accused of forming certain WhatsApp groups to coordinate the protests. Now, one piece of so-called evidence is that once the riots broke out, there was and this is from a previous bail judgment, there was a flurry of phone calls between the accused who were on this WhatsApp group. Of course, there's nothing said about what was said on these calls because you don't know the content of these calls. The High Court in the previous judgment basically says that this flurry of phone calls is suspicious, and that shows that something is wrong. Now, to me, if you are an activist and you are working on a protest and you hear that there is news of violence where people are victims or have been caught up, the most logical thing you would do would be to call each other. In fact, silence would be the more suspicious outcome after riots have broken out or violence has broken out. And on this basis, the court says that therefore it seems that some kind of conspiratorial actions are afoot. The other piece of really bizarre reasoning then now comes from the latest bail order, and that concerns one of the other accused, Shifa ur Rahman, who is the president of Jamia Millia student organization. Now, the allegation is that some funds were given to the organization to help organize the protests. Again, completely legal, but that the conspiracy was that you would use these funds to do riots. No evidence of that whatsoever. What the court says is that because Shifa ur Rahman was the president of the organization, therefore, and I'm quoting, the possibility of misuse of the position cannot be ruled out. And that on that basis, the court denies bail, and effectively now it's been 5 years. The person is in prison on the argument that because he was heading an organization, the possibility that funds were misused cannot be ruled out. Now, what you can say to this is something that really, for me, is really difficult because if there is some legal reasoning or any kind of reasoning, you can engage with that and say, okay, here's why it doesn't make sense. This is not reasoning at all. It is just something that is a pure flight of fancy. It is basically you have the person, you have the crime, and there has to be some way to fit the person to the crime, and therefore his leadership of an organization becomes the ground. And the judgments all three judgments are littered with examples of this kind. One other thing was, and I think this you all know of. When Umar Khalid's second mail was rejected, one of the arguments turned around the speech that he gave, where he had called, where most of the speech is literally him saying that peaceful protest is the way to go, and he's talking about love and all those kinds of things, and the speech begins with him saying revolutionary greetings, and what the court says is that actually revolutions can be of many kinds. So if you intended for it to be a bloodless revolution, you should have said something like bloodless revolution greetings, or something of that kind, shanti purvak krantikari istiqbal, or whatever. And because you didn't say bloodless revolution, therefore the inference is you meant a bloody revolution. And this is basically when you put language in a torture rack and torture it until it gives you the answer you want. That's what's going on here. And so these are just examples of what kind of evidence that the court finds persuasive, because there is no evidence. And if you read the bail rejections of all 9 individuals, you will find these kinds of things going on. So that the two things basically. One is that in large part, the court's decision depends upon the vague and uncorroborated testimony of anonymous witnesses, and secondly, that where there are these big gaps between what the accused actually did and what happened, the court basically fills in that gap by, for example, you were on a WhatsApp group, you made some calls, you did not say bloodless revolution, therefore you meant bloody revolution. You were the president of a society, therefore perhaps you misused funds. And you won't find anything more than this, because there actually isn't anything. And that's why when Shahrukh actually ended her remarks by saying that what in effect is going on is the criminalization of protest, and the criminalization of Muslims asserting their right to dissent and to protest against a law that very blatantly involved the discrimination in terms of citizenship. I think that is completely true, because what these judgments have done is that they have completely negated that bridge or that gap between protest and dissent and violence, and they have effectively equated the act of organizing protests, the act of organizing dissent with violence, which basically makes that space completely closed off. So I think that's a very serious problem. I want to end with briefly talking about the case of Sharjeel Imam, because I think that's important to talk about, because whereas in all the other cases, it's gone mostly on, like I said, this protected witnesses and all of that. In Sharjeel Imam's case, they have cited some speeches, which I think it's important to deal with that. So, of course, to start with, a large part of the judgment, even in his case, is about this sort of conspiracy, and they call Heyman Umar the intellectual masterminds of the conspiracy. Again, what does that word mean? Who is an intellectual mastermind? What kind of standard is that? We don't know, because the court does not tell us. But that apart, so most of the judgment, even in his cases, is on these indefensible prongs of reasoning. But in Sharjeel's case, they cite these two speeches which he allegedly gave, one of which was calling for a chakka jam in Delhi, and the second of which was allegedly saying that in Northeast you sort of blockade parts of that. Now, on the first, Chakka Jam as a means of dissent has a venerable 150-year-old history. The independent nation state of India owes its existence to very successful Chakka Jams, and even after independence, you have the Rail Roko Andolan, you have Chakka Jams. This is a classic Indian mode of dissent, and there is, like Shahrukh said, there is no evidence that who was it who was incited by these calls to then commit violence. And again, on the Northeast and the whole allegedly blockading the Northeast speech, the thing is important to note is that the standard under law is that of incitement to violence, which basically means that there should be some connection between what I say and then the violence that happens. So there is a mob. I'm standing in front of a mob. They have pitchforks in their hand and they have fire in their hand. And I say, go burn down that building. They go burn down the building. That is incitement. Saying that Northeast should be blockaded and X or Y, maybe a harsh way of putting things. The speech might be violent in nature, but there is no violence going on over there, and that distinction is really critical because the constitution and the laws don't punish violent speech. Whatever we think of violent speech, they punish violence and the incitement to violence. And that fundamental distinction has been completely missed by the courts when they have denied Sharjeel Imam bail. And that, again, I think is something that really is important to stress because, you can be as violent in your speech, but the really core thing is whether then there is violence or not, and whether there is incitement to violence or not. Because otherwise, if you were to punish every instance of violent speech, then who is it who in their life, would not be in jail, having said violent things at some point or the other? So I think, like, to sum up once and to close, basically the issue with these multiple bail orders over time are twofold. One is the way in which the court relies almost exclusively on anonymous, vague, and uncorroborated witness testimonies to effectively deny bail and end up keeping people in jail for more than 5 years. And secondly, how in the allegation of conspiracy, the court itself fills in the gaps of the prosecution with completely unsubstantiated assertions. Shahrukh mentioned Bahadur Shah Zafar's trial. What I was reminded of were the infamous Moscow trials, which Stalin in the Soviet Union used to effectively execute or send into forced labor many of the old Bolsheviks, many of his own former officers, because there again, this whole thing was that, okay, there is a conspiracy, Trotsky is the conspirator, and all of you are in some way involved in that conspiracy. It doesn't matter what specifically you've done or not done, but you are promoting the Trotskyist conspiracy. And well, we all know what history says about the Moscow trials and the judges who, in that case, were involved in the Moscow trials. Unfortunately, for the people who are incarcerated, that's cold comfort. But ultimately, what this strikes me as something similar to that. And I think what that says about our sort of collective moral sort of downfall, because of course all of us are collectively in some way, at least those of us who are in sort of the majority community, are some way collectively responsible for this. What that says about our descent into the moral abyss, I think, is something that we have to introspect about and see what we can do about that. So I will stop there and thank you very much.
Thank you so much, Gautam. There have been some requests for translation, so I'll just try to, give a summary translation of what you said, and you made very important points, so I don't think I'll be very thorough. थोड़ा संक्षेप में मैं अनुवाद करूंगी क्योंकि थोड़े रिक्वेस्ट आए हैं ट्रांसलेशन के लिए हिंदी में. ये हिंदी में ट्रांसलेशन करने में हमेशा थोड़ी दिक्कत होती है, थोड़ा थॉट भी थोड़ा चला जाता है, लेकिन सारे पॉइंट्स तो नहीं कह पाऊंगी, लेकिन जो इम्पोर्टेंट पॉइंट्स है उसके बारे में जो गौतम ने पॉइंट्स रेज किए उनके बारे में मैं थोड़ा बताऊंगी. पहली बात तो जो गौतम ने जो शाहरुख ने कहा था और नदीम ने कहा था कि यूएपीए का जैसे इस्तेमाल किया गया है इस केस में बेल डिनाई करने के लिए, ये पहले क्यों यूएपीए में बेल मिलना मुश्किल है उसके बारे में उन्होंने बात की. तो तभी उन्होंने बटाली केस के जजमेंट के बारे में बात की, जिसमें सिर्फ प्रोसिक्यूशन का एविडेंस लेने का वहां पे ऑर्डर दिया गया है कि जब भी कोई कोर्ट यूएपीए के केस में बेल की एप्लीकेशन को सुनते हैं तो उन्हें प्रोसिक्यूशन ने जो एविडेंस डाला है उसी के बेसिस पे उन्हें बेल की एप्लीकेशन डिसाइड करनी चाहिए. ये जो एक अप्रोच जो ये केस में फिर डिसाइड हुआ, उसके वजह से यूएपीए में बेल मिलना बहुत मुश्किल हो गया है और बहुत कम मुद्दों पे आर्ग्यूमेंट हो सकती है बेल के केस में. अभी ये जजमेंट के बाद जो है कोर्ट्स ने दो तरीके से यूएपीए के केसेस में बेल के एप्लीकेशंस को डिसाइड किया है. पहला जो उन लोग का अप्रोच है वो ये है कि वो आईज वाइड शट अप्रोच, जो गौतम भाटिया ने बताया कि वो अपना आंख बंद कर लेते हैं एविडेंस को लेके, या केस के अंदर वो झांकते नहीं है ये देखने के लिए कि ये एविडेंस जो है वो सही है या गलत है। उसके बारे में वो उसमें वो अपना खुद का विचार नहीं रखते, वो प्रोसिक्यूशन का एविडेंस जो है वो जैसा है उसे मान लेते हैं। तो वो एक आइज वाइड शट अप्रोच है। दूसरा जो अप्रोच है कि वो ये एविडेंस के की तहकीकात करते हैं, वो उसके बारे में स्टडी करते हैं और देखते हैं कि क्या ये एविडेंस सही है या गलत है। तो इसमें जो हम लोगों ने देखा, जो नताशा, देवांगना और आसिफ ताना को दिल्ली राइट्स कॉन्स्पिरेसी केस में जो बेल मिला है, वो इसी अप्रोच, जो सेकंड अप्रोच की वजह से मिला था। जब केस ने जब कोर्ट ने बारीकी से इस एविडेंस को देखा और उसकी खुद की जो इंटरनल कॉन्ट्रडिक्शंस है, मतलब उसमें जो बातें हम मान नहीं सकते क्योंकि वो एविडेंस में दिक्कत है या कोई फ्रेम करने की कोशिश की जा रही है, ऐसा ऐसा दिखाई पड़ रहा है, ये देख के कोर्ट ने उनको बेल दिया। लेकिन फिर बाद में जब वो मैटर सुप्रीम कोर्ट गया, तो सुप्रीम कोर्ट ने उस ऑर्डर को रिस्ट्रिक्ट कर दिया और कहा कि ये बाकी के बेल एप्लीकेशंस में इसका यूज नहीं किया जा सकता, उसे प्रेसिडेंट की तरह नहीं माना जा सकता। और इसीलिए फिर जो है हम लोगों ने देखा है दो ग्राउंड्स पे ये भी है, और दूसरा ऑफ कोर्स ये कह के कि ये जो ऑर्डर है या उन लोगों का जो उन लोगों के खिलाफ जो केस बना है वो दूसरों के ऊपर यहाँ लागू नहीं होता, इस ऑर्डर का इस्तेमाल वहां पे नहीं किया गया है। तो ये दो अप्रोचेस हैं जो कोर्ट्स लेते हैं, एक जो है वो अपनी आंख बंद कर लेते हैं और दूसरा है कि वो देखते हैं कि एविडेंस में क्या है, क्या ये एविडेंस हम मान सकते हैं कि नहीं। ये जो दिल्ली राइट्स कॉन्स्पिरेसी केस का जो बेल का रिजेक्शन का अभी हाल ही में ऑर्डर आया है, उसके लिए एडवोकेट गौतम ने कहा है कि ये उन्होंने कंप्लीट ये ना ही उन्होंने अपनी आंखें कंप्लीटली बंद कर दी है, ना ही उन्होंने प्रोसिक्यूशन के केस सिर्फ पे रिलाय किया है और आगे को उन्होंने देखा नहीं है। लेकिन दूसरा जो उन्होंने बहुत गलत काम किया है वो ये है कि उन्होंने प्रोसिक्यूशन के केस में जो भी गैप्स थे, जो उसमें प्रॉब्लम्स थी या दिक्कतें थी, उसको भी एक्सप्लेन करने की कोशिश की है और वो गैप्स को फिल करने की कोशिश की है। ऐसा हमें मानने को लगता है जब हम बेल ऑर्डर पढ़ते हैं तब। और ये जो जो ये गैप्स क्या है उसके बारे में भी उन्होंने थोड़ा बताया। पहली बात तो ये जो प्रोटेस्ट जो हुए थे, पीसफुल प्रोटेस्ट, उसका कोई कनेक्शन जो है इस वायलेंस से नहीं था, ना ही कोई ऐसा कोई एलिगेशन है कि ये वायलेंस को इंसाइट करने के लिए कोई स्पीचेस की गई। सिर्फ शार्जिल इमाम के खिलाफ एक दो स्पीचेस का यूज किया गया है, लेकिन बाकी के जो है जिनको इस केस में अरेस्ट किया गया उनके खिलाफ ये एलिगेशन भी नहीं है, मतलब ऐसा उन्होंने दावा भी नहीं किया है कि इन्होंने ऐसा कोई वायलेंस करने की कोशिश की या इंसाइट करने की कोशिश की। ये हम सब जानते हैं कि वो एलिगेशंस एक्चुअली किन के ऊपर थे, लेकिन वो अलग बात है। लेकिन दूसरी जो बात थी कि पहली बात कि ये जो प्रोटेस्ट है उसका कोई कनेक्शन भी नहीं था इन वायलेंस से या फिर इस वायलेंस के होने से। तो इसको फिल करने के लिए, ये जो बड़ा सा एक गैप है उसको फिल करने के लिए जो प्रोसिक्यूशन ने मतलब अनजान जो है विटनेस लाए, जिनके नाम का उन्होंने खुलासा नहीं किया है। मतलब ये जो विटनेसेस लाए गए हैं उनको प्रोटेक्टेड विटनेसेस के तौर पे लाए गए हैं और इनके एविडेंस, जो उन्होंने एविडेंस दिया है उसकी जानकारी कि किसने दिया है उसकी जानकारी नहीं दी गई है। और ये एविडेंस द्वारा उन्होंने ये कॉन्स्पिरेसी का चार्ज जो है वो बनाने की कोशिश की है। और ये कॉन्स्पिरेसी के चार्ज में जो उन्होंने मेन जो एविडेंस यहाँ पे जो अभी हम लोग देख रहे हैं बेल ऑर्डर में, जो उन्होंने ये गैप्स फिल करने की कोशिश की, उसमें उन्होंने ये जो व्हाट्सएप ग्रुप्स क्रिएट किए गए थे प्रोटेस्ट को ऑर्गेनाइज करने के लिए, ये ग्रुप्स का जिक्र किया है, जिन्होंने ये ग्रुप्स बनाया है इनका जिक्र किया है। तो ऐसे तरीके से उन्होंने एलिगेशंस लाए हैं। एक और जो उदाहरण जो उन्होंने बताया कि जो शिफा उर रहमान है वो एक ऑर्गेनाइजेशन के हेड है, तो उनके ऊपर जो उन्होंने जैसे एलिगेशंस का एविडेंस को जैसे यूज किया इस बेल ऑर्डर में, तो क्योंकि प्रोटेस्ट ऑर्गेनाइज करने के लिए कोई फंड्स आए थे, जो एक जायज चीज है, प्रोटेस्ट ऑर्गेनाइज करने के लिए फंड्स हमेशा रेस किए जा सकते हैं और उन्हें यूज किया जा सकता है, लेकिन उनको कैसे उन्होंने बेल, उनका एप्लीकेशन कैसे कोर्ट ने रिजेक्ट किया, ये कह के कि वो क्योंकि वो ऑर्गेनाइजेशन के हेड है इसीलिए उनको बेल नहीं दिया जा सकता। साथ ही में जो उमर खालिद है उन्होंने तो आपको पता होगा, उन्होंने जो स्पीच दी थी जिसमें उन्होंने कहा था कि पीसफुल तरीके से प्रोटेस्ट करनी है, उन्होंने उसमें क्रांतिकारी सलाम दिया था स्पीच के शुरुआत में। और उसको लेके जैसे कोर्ट ने उसे ट्विस्ट करके जैसे कहा है कि अगर उन्हें क्रांतिकारी सलाम देना ही था तो उन्हें कहना चाहिए था कि वो एक ब्लडलेस रेवोल्यूशनरी ग्रीटिंग, मतलब खून खराबे के बिना होने वाला क्रांतिकारी सलाम, ऐसा कह के उन्हें कहना चाहिए था। नहीं तो फिर उनके क्रांतिकारी सलाम का मतलब कुछ और हो सकता है। तो ऐसे 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 रीजनिंग उन्होंने ये ऑर्डर में दिए हैं। शर्जील इमाम एक है जिनके खिलाफ चक्का जाम के बारे में मतलब को एडवोकेट करने का एक आरोप डाला गया था कि उन्होंने स्पीच में चक्का जाम के बारे में बात की थी। हम सब जानते हैं वो स्पीच के बारे में। पहली बात तो जो एडवोकेट गौतम ने कहा कि चक्का जाम बोलना या उसके बारे में उसको उसको एडवोकेट करना, पहली बात तो क्या वो एक गुनाह है, वो एक इम्पोर्टेंट जो सवाल आता है। हम लोगों ने देखे हैं बहुत सारे आंदोलन जो हुए हैं उसमें ब्लॉकेड्स होते हैं, उसमें पीसफुल तरीके से अपनी अपनी बात रखने के लिए भी अलग अलग तरीके अपनाए जाते हैं, लेकिन वो वायलेंट तरीके नहीं है, ना ही वो कोई वायलेंस इंसाइट करने का कोई तरीका है। लेकिन ये चक्का जाम का जो शब्द को कैसे यूज किया गया या उनकी स्पीच को कैसे यूज किया गया उसमें। दूसरी बात जो उन्होंने रेज की इसी स्पीच को लेके कि सिर्फ कहना कि चक्का जाम करना है, क्या वो इनफ है। वो जो स्पीच देते हैं उस उससे कोई वायलेंस इंसाइट होना चाहिए। क्या ये प्रूव कर पाया प्रोसिक्यूशन कि उससे कोई वायलेंस इंसाइट हुआ? ये भी एक बहुत बड़ा गैप है जो इस बेल ऑर्डर में दिखाई पड़ता है। तो उन्होंने राउंड अप करने के लिए जो उन्होंने कहा कि इसीलिए दो बहुत इंपॉर्टेंट चीजें जो इसमें से निकल के आती है कि पहली बात तो ये एनोनिमस टेस्टिमनीज का यूज किया गया है क्योंकि उसके बिना कोई एविडेंस तो है ही नहीं उनको बेल रिजेक्ट करने के लिए। और दूसरा कि ये कॉन्स्पिरेसी चार्ज को साबित करने के लिए या उसको सिर्फ बेल के लिए भी उसको मुकम्मल करने के लिए उन्होंने जो गैप्स कैसे फिल किए हैं, जो जो भी उन्होंने तरीके भी यूज किए हैं ये गैप्स फिल करने के लिए, क्या वो लीगली सस्टेनेबल है या वो नहीं है। तो ये इंपॉर्टेंट पॉइंट्स एडवोकेट गौतम भाटिया ने ऑर्डर की गहराई में जाके बताए हैं। और साथ ही में जो उन्होंने कहा, जो बाकी के स्पीकर्स ने भी अभी कहा है कि प्रोटेस्ट को कैसे क्रिमिनलाइज किया गया है इन ये जो केसेस से हमें पता चलता है और ये जो बेल ऑर्डर के रिजेक्शन है, और उसमें हम सबकी रिस्पॉन्सिबिलिटी क्या है एज सिटीजन्स, हम लोग कैसे इस केस को देखते हैं, इसको हम कैसे इसका हमारा क्या रिस्पॉन्स होना चाहिए, हम पर क्या रिस्पॉन्सिबिलिटी पड़ती है जब कोर्ट ऐसे जजमेंट्स पास करते हैं। तो ये भी एक बहुत इम्पोर्टेंट सवाल उन्होंने रेज किया और ये डेफिनेटली हमारे चर्चे में बाद में आनी चाहिए। तो ये बस मैंने बहुत संक्षेप में अनुवाद किया है, थोड़े पॉइंट्स रह गए होंगे, अगर कुछ है तो बाकी के लोग भी कंट्रीब्यूट कर सकते हैं चैट पे। नाउ गोइंग टू आवर नेक्स्ट स्पीकर, आई वुड लाइक टू इनवाइट हर्षित आनंद. Harshit Anand is an advocate practicing in Delhi, and he's involved in public law practice as well as in housing and property litigation. हमारे अगले स्पीकर जो है वो है एडवोकेट हर्षित आनंद. वो एडवोकेट है, दिल्ली में प्रैक्टिस करते हैं और वो ह्यूमन राइट्स का काम, पब्लिक लॉ की प्रैक्टिस भी करते हैं और साथ ही में उनका रियल एस्टेट लिटिगेशन में मतलब प्रॉपर्टी को लेके भी वो मैटर्स करते हैं. तो हर्षित, कैन आई रिक्वेस्ट यू टू अनम्यूट योरसेल्फ एंड प्लीज शेयर थॉट्स विद अस.
Thank you, Lara. I hope I'm audible to everyone.
You are. Can you pin Harshit, please?
So, मुझसे पहले जितने भी वक्ता आए हैं इन्होंने केस के बारे में, केस की बारीकियों के बारे में काफ़ी डिटेल्ड डिस्कशन किया है. डिस्कशन के दौरान मुझे एक हरिशंकर परसाई, जो भारत के बहुत प्रसिद्ध लेखक और व्यंग्यकार थे, उन्होंने एक बार लिखा था कि कानून जो होता है वो अंधा नहीं होता है, कानून काना होता है, क्योंकि उसे केवल एक तरफ का ही दिखाई देता है. And of course, this was a satirical take on one-sided application of laws and how laws are always used by the oppressing community or the oppressing party for the oppression of the weaker party. And I think this case is probably the best example of what Harishankar Persai said about application of these one-sided application of laws in the 20th century. And one thing which is very clear from whatever the previous speakers have said is that in the government's eye, this case is to serve as an exemplary case for creating a larger chilling effect in the Indian society. And the larger chilling effect is that if you are someone from a minority community, and if you dare to raise your voice against unjust laws, unjust policies of the government, if you are somebody who has the power of mass mobilization, if you're a good speaker, if you're an influential personality, if you are somebody who is ideologically driven, and you can inspire people to come on the streets and protest against, mobilize against unjust laws, something which Sharjeel was able to do, something which Umar was able to do, something which Gulfisha was able to do, you will be made an example of, so that other people of your community see that example, and there is a chilling effect created so that they do not dare to do that again. केस के बारे में प्रोसिक्यूशन का जो केस है उसमें क्या लूप होल्स हैं, क्या कमियां हैं, लीगली कैसे वो गलत है, वो गौतम ने और शाहरुख ने तो बताया है। मैं यूएपीए के एक दूसरे एस्पेक्ट के बारे में बात करना चाहूंगा। यूएपीए एक कुख्यात लॉ है, इट्स अ ड्रकोनियन लॉ वेयर बेल इज वेरी वेरी डिफिकल्ट टू सिक्योर। दिस इज समथिंग दैट ऑल ऑफ अस नो। द केस ऑफ द प्रोसिक्यूशन इज समथिंग दैट हैज बीन एक्सप्लेन्ड। बट एक एस्पेक्ट है यूएपीए का जो कि पिछले 4-5 सालों में क्लैरिफाई हुआ है भारतीय कोर्ट्स के द्वारा, भारतीय सुप्रीम कोर्ट के द्वारा। लेकिन हमारे बेल ज्यूरिस्प्रूडेंस में, द बेल ज्यूरिस्प्रूडेंस विच वी हैव इन इंडिया, उसमें एक कल्चर ऑफ कन्वीनियंस है। And why do I call it a culture of convenience? I have 3 primary reasons why I call it a culture of convenience while interpretation of established precedents of in bail jurisprudence. And the first point is, and all these 3 elements which I'm going to discuss is very clearly visible and available in these 2 judgments which came a few days ago, rejecting bails of all these accused in FIR 59. The first element is a complete disregard for existing precedent. Either there is a complete disregard or there is a selective application. The second element is that there is no real engagement with the nature of allegations and the merit of the allegation. There is a simple restatement of the allegations in the judgment itself, which is to say that the allegations are taken at face value without the court delving into the real merits and the meaning or the reasonableness of what the case is. And the third and the most disturbing aspect of this is that a judgment is read against and interpreted against its very clear intent. अब मैं ये क्यों कह रहा हूं, मैं इसे सरल भाषा में एक्सप्लेन करने की कोशिश करूंगा। यूएपीए में एक केस मेरिट्स पे है, जो दूसरा केस है वो है पीरियड ऑफ इनकार्सरेशन ऑलरेडी अंडरगॉन पे। This is a case where all of us know that these accused people have been behind bars for more than 5 years now. This alone should be a very important consideration while deciding whether bail should be granted or not. And this is not something which is a figment of imagination of a lawyer or comes from a sympathetic point of view. This is a position that in the last 5 years has been consistently reiterated by none other than the Indian Supreme Court. And these judgments, while they have been noted in this judgment, which has denied bail to Umar and other people, the main aspect of this judgment, the real intent of this judgment is somehow lost in the conclusion of the judgment. अब ये जो कुछ जजमेंट्स हैं, मैं इनके बारे में आपको ब्रीफली बता देता हूं, क्योंकि यूएपीए के बारे में ये कुख्यात है कि यूएपीए अगर आप पे एक बार लग जाए तो आपको बेल नहीं मिल सकती है। लेकिन 2021 से 1 फरवरी 2021 को नजीब जजमेंट आया था, सुप्रीम कोर्ट के 3 जजों के द्वारा ये जजमेंट दिया गया था। एंड द सुप्रीम कोर्ट इन द नजीब जजमेंट स्पेसिफिकली नोटेड 2 कंसिडरेशंस। It said length of the period of incarceration, जितनी देर accused जेल में already रह चुका है, and second, the unlikelihood of the trial being completed, क्या ट्रायल नियर फ्यूचर में कंप्लीट हो सकता है, क्या अगले 3 महीने 6 महीने 1 साल में ट्रायल कंप्लीट हो सकता है। इन दोनों कंसिडरेशन को कोर्ट को अपने संज्ञान में लेना पड़ेगा, और फिर कोर्ट को यह देखना पड़ेगा कि अगर ये दोनों चीजें नहीं हो सकती हैं तो जो अक्यूज्ड जेल के अंदर है उसके पार्ट 3 राइट्स जो कॉन्स्टिट्यूशन में गारंटीड है, जो मौलिक अधिकार उसका संविधान में गारंटीड है, वो वायलेट नहीं होना चाहिए। और यहाँ पे किस पार्ट 3 अधिकार की बात हो रही है? यहाँ पे लाइफ और लिबर्टी का जो अधिकार आर्टिकल 21 में दिया गया है, जो कि हर इंसान को है जो भारत में रह रहा है, जो भारत में है, उसका लाइफ और लिबर्टी वायलेट नहीं होना चाहिए। ये 1 फरवरी 2021 को, आज से 4.5 साल पहले, सुप्रीम कोर्ट का एक 3 जज बेंच बोल चुका है। And the Najib judgment is cited very widely. Those who are here and those who practice UAPA and related laws, they know that the Najib judgment is the go-to judgment for any kind of relief that you seek in these laws involving stringent provisions of bail. ऐसा नहीं है कि नजीब जजमेंट के बाद ज्यूरिस्प्रूडेंस चेंज हो गई है। नजीब जजमेंट के बाद पिछले 5 सालों 4.5 साल में कम से कम 6 ऐसा इंस्टेंस है जहां पे सुप्रीम कोर्ट के 2 जज बेंच ने इसको बार बार रीइटरेट किया है। अगर मैं आपको कुछ एग्जांपल्स दे सकूं तो इस 1 फरवरी 2021 के जजमेंट के बाद 28 अक्टूबर 2021 को सुप्रीम कोर्ट का एक और जजमेंट आता है, थ्वाहा फसल वर्सेस यूनियन ऑफ इंडिया। ये 2 जज बेंच जजमेंट था। इसमें भी सुप्रीम कोर्ट नजीब जजमेंट के बात को दोहराती है और कहती है कि क्योंकि अक्यूज्ड काफी लंबे समय से जेल के अंदर हैं और ट्रायल खत्म होने की कोई संभावना नहीं है, तो इस ग्राउंड पे ही उन्हें बेल मिल जाएगी, केवल इसलिए क्योंकि आप पे ग्रेव एलिगेशंस हैं, आप पे टेररिज्म चार्जेस हैं, जो कि सब्सटेंशिएटेड ऑफ कोर्स नहीं है, बिकॉज अभी तो ट्रायल आपका शुरू भी नहीं हुआ है। तो इसीलिए केवल ऑन डिले ऑफ ट्रायल एंड द पीरियड ऑफ इनकार्सरेशन अंडरगॉन आप बेल मेरिट करते हैं। ये तो सेकंड एग्जांपल है। फिर 28 अक्टूबर 2021 के बाद 1 दिसंबर 2021 को एक और जजमेंट आता है सुप्रीम कोर्ट का, असीम कुमार भट्टाचार्य वर्सेस नेशनल इन्वेस्टिगेशन एजेंसी। उसमें सुप्रीम कोर्ट फिर से ये बात कहती है। पिछले साल 13 अगस्त 2024 को एक सुप्रीम कोर्ट एक बहुत अहम जजमेंट देती है यूएपीए पे। यहाँ पे जो अक्यूज थे वो पीएफआई के मेंबर थे और जस्टिस अभय एस ओका की बेंच ने ये जजमेंट पास किया था। और जस्टिस अभय एस ओका ने क्या किया था कि उन्होंने नजीब जजमेंट के रीजनिंग को, जो कहता है कि अगर लंबा इनकार्सरेशन का पीरियड है तो आप मौलिक अधिकार जो लाइफ एंड लिबर्टी का है उसको वायलेट नहीं कर सकते हैं, उसको जस्टिस अभय ओका एक और स्टेप आगे ले गए और उन्होंने अपने जजमेंट में क्लियर शब्दों में कहा कि बेल इज द रूल एंड जेल इज द एक्सेप्शन इवन इन द केस ऑफ यूएपीए। अगर आप वो जजमेंट खोल के पढ़ेंगे तो उसमें देयर इज अ क्लियर रीस्टेटमेंट ऑफ दिस प्रिंसिपल, दैट द फंडामेंटल प्रिंसिपल ऑफ क्रिमिनल लॉ, दैट बेल इज द रूल and jail is the exception, has to be read into UAPA provisions as well. And the only fact that the bail provisions are stringent or the charges are very grave in nature will not be a bar to bail if somebody has been languishing behind bars for a very long period of time. अब यहाँ पे जो नोट करने वाली बात है कि ये जो 2 जजमेंट आए हैं अभी कुछ दिनों पहले, जिनमें उमर शारजील, गुलफिशा, तस्लीम, इन लोगों को बेल रिजेक्ट हुई है, इसमें जलालुद्दीन जजमेंट जो ये अभय एस ओका का जजमेंट था, इनको संज्ञान में लिया गया या नहीं लिया गया। और यहाँ पे मैं अपने पहले दोनों पॉइंट पे आऊंगा। ईदर देयर इज अ कंप्लीट डिसरिगार्ड ऑफ एस्टैब्लिश्ड प्रेसिडेंट्स और द वेरी जजमेंट आफ्टर बीइंग साइटेड has been read against the intent of the judgment itself. तो जो जज साहब हैं जिन्होंने ये जजमेंट दिया है, इन्होंने ये सारे, इनमें से कुछ प्रेसिडेंट्स नोट किए हैं और इन्होंने कहा है कि हाँ ये प्रेसिडेंट तो है, बट इसका केस बाय केस इम्प्लीमेंटेशन होना है। ये केस लागू होगा या नहीं, whether or not it is applicable on the facts of the case, is something that has to be seen on a case to case basis. इनफैक्ट जलालुद्दीन जजमेंट का जो पैराग्राफ है जो ये कहता है कि आर्टिकल 21 will override the consideration of section 43(d)(5) of the UAPA in cases where there has been a long period of incarceration or where the trial is not likely to be completed in the near future. उस पैराग्राफ को कोट किया गया है, लेकिन वो इतना महत्वपूर्ण पैराग्राफ है लेकिन उसके इम्प्लीकेशन को कहीं डिस्कस नहीं किया गया है। इनफैक्ट पूरे जजमेंट में अगर आप देखेंगे तो कहीं भी इस चीज के बारे में कोर्ट ना ही परटर्ब्ड है, ना ही उसने प्रोसिक्यूशन से कोई सवाल पूछा है कि आखिर ये लोग इतने समय से जेल के अंदर हैं, तो आपने एज ए प्रोसिक्यूशन इस ट्रायल को एक्सपेडाइट कराने के लिए क्या किया है? आपके 700 विटनेसेस हैं, आपने आखिर अभी तक ट्रायल में, अगर अभी तक चार्जेस पे बहस हो रही है, तो प्रोसिक्यूशन का प्लान ऑफ एक्शन क्या है? कि कहीं भी प्रोसिक्यूशन से ये सवाल नहीं पूछा गया है। तो ये जो दो एलिमेंट्स हैं कि या तो आप इस्टेब्लिश्ड प्रेसिडेंट को कंप्लीटली दरकिनार कर दें, या फिर आप उसे साइट करें, और जो उसका सबसे महत्वपूर्ण एलिमेंट है उसे आप डिस्कस ही ना करें। और जो तीसरी चीज है, विच इज क्रिएटिंग दिस कल्चर ऑफ कन्वीनियंस और कल्चर ऑफ पॉलिटिकल एक्सपीडियंसी इन बेल jurisprudence, बेल इंटरप्रिटेशन ऑफ बेल प्रोविजंस इन इंडिया, is what I spoke of earlier, the lack of real engagement with allegations which are put forth. Gautam also spoke on this, but I would just like to reiterate. What are the allegations? What are the allegations against Sharjeel or Umar or Gulfisha? The allegation against Sharjeel is that they were the heads of WhatsApp groups and they were people behind printing of pamphlets, uh, organizing Chakka Jam, calling for bunds. This is the allegation. There is no proximate connection between this very legitimate right to protest and the actual violence that took place in Delhi in Delhi riots. And at no point of time does the court ask this question to the prosecution कि अगर आप ये कह रहे हैं कि हाँ शारजील ने बंद बुलाया, शारजील ने चक्का जाम के लिए लोगों को बुलाया, शारजील ने व्हाट्सएप पे ये लिखा, तो आप ये कनेक्शन तो एस्टैब्लिश कीजिए कि जो रियल वायलेंस हुआ है उसका इस स्पीच से क्या कनेक्शन है, क्या संबंध है। गुलफिशा पे जो इल्जाम लगे हैं वो और भी ज्यादा कॉमिकल हैं, हालांकि दिस इज अ ट्रेजेडी ऑफ अनस्केलेबल प्रोपोर्शंस, लेकिन अगर ये ट्रेजेडी नहीं होती तो ये बहुत ही एक थिएटर ऑफ द अब्सर्ड होता। गुलफिशा पे आरोप ये लगा है कि गुलफिशा ने एक व्हाट्सएप ग्रुप बनाया मुस्लिम औरतों की मोबिलाइजेशन के लिए, जहां पे वो मुस्लिम औरतों को सीएए कानून के खिलाफ भड़का रही थी। गुलफिशा पे ये भी इल्जाम लगा कि वो सिंस पिंजरा तोड़ की व्हाट्सएप ग्रुप की एडमिन है, तो वहां भी वो मुस्लिम औरतों को मोबिलाइज कर रही थी। क्या मुस्लिम औरतों को मोबिलाइज करना इस देश में एक जुर्म है? क्या मुस्लिम औरतों को यह बताना, सही हो या गलत हो, क्या मुस्लिम औरतों को यह बताना कि ये सीएए कानून जो है ये गलत कानून है या इससे आपको एक दो तीन दिक्कतें हो सकती हैं, क्या इस देश में ये जुर्म है? ये सवाल कोर्ट कहीं नहीं पूछती है। इनफैक्ट अगर आप जजमेंट पढ़ेंगे तो यू विल थिंक दैट प्रोबेबली दीज कंसिडरेशंस डिड नॉट इवन अराइज इन द कोर्ट्स माइंड. And this is what makes these judgments very, very problematic, because you can see that the court is very clearly being not honest in its analysis and conclusion. And that is something which is the most troubling aspect of this judgment. जो exemplary effect है इस जजमेंट का, या जो एक लार्जर मैसेज है जजमेंट समाज को दे, भारतीय समाज को दे रही है, वो ये है कि अगर आप सरकार के कुछ महत्वपूर्ण बिंदुओं के खिलाफ जाओगे, अगर आप सरकार, इफ यू टारगेट द गवर्नमेंट against some very specific things which are very dear to the government, then you will meet this fate. And then nobody will come to your rescue. Of course, the state agencies will not come to your rescue because the state agencies are directly controlled by the central executive. And their independence, let's not go into the independence of the state institutions in India. But जो एक इंस्टीट्यूशन है जिसकी प्राइमरी ड्यूटी है कि आपके मौलिक अधिकारों की रक्षा करे, अगर वो इंस्टीट्यूशन भी इस तरीके से एनालाइज करेगी हमारे लॉज को, इस तरीके से दरकिनार करेगी इस्टेब्लिश्ड प्रेसिडेंट्स को, तो फिर लिटिगेंट्स या फिर जो सिविल सोसाइटी के मेंबर्स हैं जो अनजस्ट लॉज के खिलाफ प्रोटेस्ट कर रहे हैं या अनजस्ट पॉलिसीज के खिलाफ लिख रहे हैं, बोल रहे हैं, उनके पास इस देश में क्या रेमेडी रह जाएगा? तो दिस इज अ कंसेप्ट, दिस इज व्हाट रेजेस अ वेरी इंपॉर्टेंट क्वेश्चन ऑन द फ्यूचर ऑफ similar cases in India, and which of the rights are actually the rights which enjoy protection of the law. Because right now what it appears after this judgment is that all your rights are not tested on the touchstone of part 3 of the Constitution or provisions of the Constitution. The validity of your speech is now tested on whether or not the executive wants you to make those speeches, and whether or not executive is comfortable with you doing or taking your protest to that level. 19th century और 20th century अमेरिका में एक ऐसा दौर आया था जब उस दौर को जिम क्रो एरा कहते थे, और उस दौर में there were a lot of incarcerations of black people in the USA. And what was notable about those incarcerations was that although the laws were not overtly racial, if you read the laws, if you do a plain reading of the laws, you will not find anything overtly racial in the laws. But the way those laws were implemented, they were only used to target one particular community. And it was very clear to the public at large, the white community knew it, the black community knew it, that the application of those laws will always end up in the blacks going to jail. आज भारतीय समाज में यूएपीए जो कर रहा है, जिस तरीके से यूएपीए को लागू किया जा रहा है, ये आज हमारे दौर का जिम क्रो एरा यहाँ पे क्रिएट कर रहा है, जहां पे आपको पता है कि यूएपीए कहने को तो हिंदुओं पे भी लागू होगा, मुस्लिम्स पे भी लागू होगा, बट अगर कोई माइनॉरिटी कम्युनिटी का कंसाइंशियस इंसान, एक पब्लिक स्पिरिटेड इंसान मास मोबिलाइजेशन करेगा, या सरकार जिन पॉलिटिकल मुद्दों को भुनाना चाहती है उसके खिलाफ जाएगा, तो उस पे यूएपीए लगा के उसे जेल भेज दिया जाएगा. Now, our courts cannot shut their eyes to this political reality. And be very clear about it. The eyes of the courts are not close to political reality. Because had the eyes of the courts been close to political reality, the judgment which came out 4 days ago would have been something else. Because the court knew that these people have been behind the bars for 5 years. The court knows that less than a year ago, there has been a judgment of the Indian Supreme Court which says that if there is long incarceration, if the trial cannot be concluded in a very short period of time, you have to let people out. जो एक बहुत कॉमन फ्रेज है यूएपीए के बारे में कि प्रोसेस ही पनिशमेंट है, जो प्रक्रिया है वही आपकी सजा है, इसके खिलाफ सुप्रीम कोर्ट ने जजमेंट दे दिया है. लेकिन इतना क्लियर डिसरिगार्ड है क्योंकि कोर्ट को भी पॉलिटिकल रियलिटी पता है. कोर्ट को पता है कि आज जो भारतीय सरकार है, जो सेंट्रल एग्जीक्यूटिव है, उसके लिए कौन से मुद्दे अहम हैं और किन मुद्दों पे बिल्कुल भी समझौता नहीं किया जा सकता है. और ये एक ऐसा मुद्दा है जिस पे बिल्कुल भी समझौता नहीं किया जा सकता है. एंड दैट इज व्हाई दिस टेस्ट, this question of release of Umar and Sharjeel and Gulfisha and Khalid Safai and all these people who are inside the jail under this FIR 59 of 2020, this today, their release is the real test of Indian progressives and Indian progressivism. अगर आप इस मुद्दे पे नहीं बोल रहे हैं, अगर आप इस मुद्दे पे चुप हैं, तो फिर आपने डेमोक्रेसी के कॉज को ऑलरेडी फेल कर दिया है. क्योंकि अगर हम इस चीज से समझौता कर लें कि हमारे देश में 5-10 नौजवानों को केवल मास मोबिलाइजेशन के लिए और अपने संवैधानिक अधिकारों के रक्षा के लिए जेल के अंदर 5 साल डाला जा सकता है और उनके पास कोई रेमेडी नहीं है, ना कोर्ट उनके लिए आएगी, ना सेंट्रल एजेंसी उनके लिए आएगी, ना मीडिया उनके लिए आएगा, ना प्रोग्रेसिव्स उनके लिए आएंगे, तो फिर उनके लिए आएगा कौन? If you make your peace with the incarceration, with this, the most unjust incarceration of Umar and his colleagues, then we have already failed the test of all other progressive causes in India. That's it. That's all I have to say. Thank you.
Thank you, Harshit. You're very eloquent, and I think you raised both the important points I think that we were looking to hear. One, of course, on how the application of this relief for bail has not been granted in a uniform manner, and there is a bias that is operating, which you brought out, through proper illustrations. I think that's a very important point that we have to recognize today. It is a reality of today's time, and we see this reality reflected in judgments like this. which reinforce the targeting of people from vulnerable groups, from minorities. We've seen this against Muslims, Adivasis, how UAPA has been used. This is the reality of today's time. And the courts have been aiding this process, and you have brought out the culpability of the courts in this, which is a very important point. Another very important point that you brought, and which we're very glad that you did, was that how there has been a complete denial of the right to bail, where bail was supposed to be the rule and jail was supposed to be the exception. Even in UAPA cases, we are seeing now that it is jail and not bail, which has become the new normal. This was something that Saurav Das, our next speaker, was also supposed to cover, who's an independent journalist. He was writing about this, but he fell sick today in the morning and he was not able to address us on this. So we're very happy that you also managed to touch upon this very important point on how there has been a denial of the right to bail, and how not granting bail has become the rule now in cases against political prisoners, against minority rights activists, against people from the Muslim community, and we're seeing this happen over and over again in the recent past. And the courts are reinforcing these stereotypes and making these same decisions, and also, in a sense, then becoming complicit in the state's plan. So these really important points that you brought out today, I would really like to thank you for. जैसे मैंने कहा, सौरभ दास जो हमारे नेक्स्ट स्पीकर है, वो आज आ नहीं पाए क्योंकि वो बीमार पड़ गए थे सुबह को, और उन्होंने बताया था कि वो इस तकलीफ की वजह से नहीं आ पाएंगे। लेकिन वो जो पॉइंट बात करने वाले थे कि आज की तारीख में जैसे जेल जो नया नॉर्मल हो गया है, बेल कोर्ट नहीं ग्रांट करती, जब कोर्ट का ये जब हमारे कानून का ये प्रिंसिपल रहा है कि बेल जो है वो रूल होना चाहिए, और जेल जो है जहाँ पे जरूरत हो वहीं पे जेल का ऑर्डर देना चाहिए। लेकिन आज हम लोग देख रहे हैं कि यूएपीए के केसेस में जैसे बेल की का जो राइट है, जो यूएपीए के केसेस आज पॉलिटिकल प्रिजनर्स के ऊपर, या जो मुस्लिम एक्टिविस्ट है, या फिर जो आदिवासी एक्टिविस्ट है, या जो अलग हाशिए से आए वाले ग्रुप से, वहां पे उनके खिलाफ तो जैसे बेल दिया ही नहीं जा रहा है। तो ये एक आज की जो रियलिटी हो गई है, उसके बारे में भी हर्षित ने जो बताया, वो आज सौरभ दास कवर करने वाले थे। तो मैं हर्षित का उसके लिए भी शुक्रिया अदा करना चाहूंगी कि ये पॉइंट भी उन्होंने सबके सामने रखा। और इसके साथ आई थिंक हम एक जो हमारा लास्ट सेगमेंट है आज के चर्चा का, जो हम पहली बात तो हम सबका क्या विचार है, इसमें बहुत सारे कमेंट्स आए हैं, बहुत सारे लोगों ने चैट बॉक्स में लिखा है। उनमें से थोड़े कमेंट्स जो है वो पढ़ने लायक है, और मैं चाहूंगी अगर कविता, इफ वी हैव द टाइम, should we take some time out to read some of the comments before we go to the concluding part of the
yeah, I think we do need to read out the comments, and I think there were some queries,
there are some
although they were
questions also that have
answered.
come.
Yeah,
yes.
I think it's important.
Yes. So we'll take some additional time, even if we are, even if it means that we over exceed our meeting time by a little bit, to read out some of the comments and also some of the questions that have come. And first, I would like to, that there has been a question that has come at least twice on the chat, where asking the speakers to elaborate on what grounds the court denied, the parity argument, or refused to grant bail to the applicants, by saying that the principle of parity could not be applied in respect of Asif, Natasha, and Devangana's judgment. So, if one of the speakers would like to address this, can I invite Gautam? Gautam, if you can come in and address this comment, please.
Yeah, sure. So the parity argument was made, and the court rejects it on a few grounds. I think the Well, the most egregious example of the rejection of parity is Gulfi Shah's case, because basically the allegations against her are pretty much identical to the ones against Natasha Narwal and the Wagner Kalita, who were granted bail for very good reason. And the allegations were of being part of Pinjra Tod and those WhatsApp groups and all of that. And pretty much, again, the case entirely based on the evidence of the anonymous, protected witnesses. So in that case, the argument for parity was to me unanswerable, but the High Court just says that every case is depending on its own facts and circumstances, and therefore you can't judge one by the other. And here the allegations are more serious. In the other cases, the other 8 cases, the court again basically says that in a conspiracy, everybody plays different roles. And so, for example, the court says that the allegations against Sharjeel Imam and Umar Khalid are that they were the intellectual masterminds of the riots, and therefore it's a more serious allegation. With some of the other accused, the Khalid Saifi, and the example I gave, the president of the association, is like, okay, they were doing funding, and therefore that is the point of difference. So in each case, the court sort of finds some kind of difference and says, therefore, there's no parity. Or the irony is that the irony is that the court on the one hand says, okay, like every individual in a conspiracy has different roles and you can't attribute one to the others. But they literally deal with the bail orders in buckets. So they deal with Umar's and Sharjil's cases together, and then there are like buckets of like 3 or 4 people that they deal with together. So it's a big contradiction here. On the one hand, you're saying that there's no parity, everybody's case is individual, but then you're literally sort of addressing and rejecting bail of people in groups. So again, I think that parity was obviously a very strong argument, because also one thing that the court ignores, and I mean this is also again attributable to the Supreme Court saying that you can't cite the Devangana, Natasha, and Anas, the Asif Iqbal Tana judgment as precedent. I think that also plays a part there. But in that case, the High Court was very clear that there was no link between the organization of the anti-CAA protests and the communal violence, and the court makes it clear that exercising in those protests is an act of constitutionally protected dissent, and there's been no link drawn between the organization of the protests and the violence. So if you apply that logic, the case for parity is again unanswerable. But unfortunately, in an act that I have written about, and I find one of the most unjustifiable things the Supreme Court has done recently, and there's a long list of those things, to say that you can't treat this as precedent is just something bizarre. But that's again the reason why finally the High Court has found it very easy to deny the argument of parity.
Thank you, Gautam. The way in which Gulfi Shah's case has been dealt with, which Gulfi Shah's application has been decided in the bail order, where they have literally implicated her and shown her role as being more than the others for being able to organize, women in the community, and for those 2 WhatsApp groups, clearly shows, how she has been actually persecuted only for a critical role in mobilizing Muslim women. And again, there is a huge sort of a thought that has been put in by the judge, which is again something that Harshit spoke about, reflective of the bias. So these important points again that have been raised on the issue of non-application of these judgments. We have another question that had come in earlier on, and it was addressed to Nadim. Nadim, आपके लिए क्वेश्चन है कि क्या आपको अभी लग रहा है कि उच्च न्यायालय भी सरकार के दबाव में है, और वो सिर्फ उनके आदेश पढ़ रहे हैं और इसीलिए न्याय की कोई गुंजाइश नहीं है, और इस सिचुएशन में क्या किया जा सकता है? क्या हम जस्टिस गवई को संपर्क कर सकते हैं, या शायद से कहने का ये मतलब है क्या इन मुद्दों को लेके सीजेआई को कोई पिटीशन जानी चाहिए? ये क्वेश्चन आया था। नदीम, आप कुछ बोलना चाहेंगे? Nadim, are you in the chat? नदीम, क्या आप मीटिंग में हैं? आप कुछ
He is very much there. I'll just call him.
Okay, I think we can put that question on hold for the time being once he comes. There are questions that have also come on, which I think have already been answered. One question that came in was, are the loopholes in the charge sheet a valid ground for granting bail? And why does the state feel threatened by democratic protests of Muslims? I think these are some questions that have already been answered. However, the speakers, if they want to add, they can definitely add. But going to another, question that was brought in was a parallel that when the farmers' agitation continued for a year, it was not criminalized in the same fashion, and farm laws were withdrawn. But in case of anti-CAA protests, we see an example is sought to be made of activists who had no role in the violence, but were only opposing citizenship amendment laws. So, since Harshit, you spoke about the bias that we are seeing, and this is the question that it also comes from the same place. Can you please address this?
Yes, I'll try to address it, Lara. See, I think I would not see this particular protest against the Citizenship Amendment Act is something that I would keep separate from, say, the Kisan agitation or protest against or any kind of disagreement with any other law. And I think these are conversations that we need to have more openly, because what happens is the way court proceedings are conducted in India, a lot of politics informing these laws or these actions of the state are not directly conveyed to the court, thinking that political considerations should not influence, rightly so, legal proceedings. But like I mentioned in my speech also, legal proceedings are never devoid of politics. And only because you are not keeping your side of the politics very clearly before the bench does not mean that the state's politics will not inform the decisions of the judiciary. So the larger project behind going after people who raised their voices against the Citizenship Amendment Act was to ensure that this project of rendering Muslims as second-class citizens, that is not affected. And a clear message goes to the constituency of the ruling party that, look, if these people dare to come on the streets, this is what we are going to them. So message has to go to both sides. The message has to go to their constituency that, look, we'll take this action against them like we did in the past. And the message has to go to the oppressed community also, to this side also, that if you dare to do this, then this is the fate you will meet. The problem which happens is when as lawyers we argue in courts of law, we argue on provisions, we argue on precedents, we argue on how sections have been interpreted by different benches in the last 40 years, 50 years. But this context, this larger political backdrop is never openly discussed. And this is something I don't know how this will be done. I am probably not that equipped to lay down the framework of doing this. But this political reality also has to inform criminal litigation in India. Because while we think that that these matters in courts, the way these litigations are conducted, while we think that these are independent of political considerations, but actually they are not. Because the judgment, while not saying a lot of things, if you see the current judgment, it says a lot of things. It assumes a lot of things. And those assumptions are informed by politics of the ruling party. So I think some truths have to be told in courts of law as well as like in public discourse.
I think that's where I'll just make you wait for a minute. That's where I think the follow-up question also comes in, that how do we challenge this discrimination that we are seeing in the implementation or application of UAPA in view of the fact that democracy and constitution is being attacked in the process. The question that has come from Suhas Kaulekar, and like you said, that there is no easy answer to what can be done. But do you have any thoughts on how the argument on discrimination and bias can actually be used in the constitutional courts or in the higher courts at least?
I'll try to answer it, Lara, but see, ultimately what happens is any any interpretation of a provision of law, like all of us know, has to be true to the constitutional provisions like 14, 19, and 21, which inform all laws in India. Now, if a law like UAPA or any other stringent law, for example, let's take any other law, the misuse of which or like political use of which we have seen in the last few years. Take PMLA, for example. Now, the only thing that is needed, and this is something that some judges have shown also. I would not like to take names of judges because that somehow kind of attributes political color to their judicial work. But if you see certain judgments of the last couple of years, you will see that these judges did not do anything extraordinary. For example, those judgments of the last couple of years in which bails were granted to chief ministers and political party leaders in PMLA cases in the last 2 years, you see nothing extraordinary was done. The bail provisions, the stringent bail provisions were taken and they were tested on the touchstone of the Constitution. And what was simply seen was whether the test of life and liberty being sacrosanct and not being sacrificed on the altar of an unreasonable law asking for not or rather not giving the defense any chance at the stage of bail. Because what do you see at the stage of bail? Like Gautam also pointed out, what you see at the stage of bail is not a mini trial, but a prima facie case, whether the basic offenses, the basic ingredients are met or not, and whether the other conditions like flight risk or tampering of evidence. You just check all of this. Now, what these laws do, what laws like UAP or PMLA do is that they put in extra considerations. They mandate that whatever case is presented by the prosecution has to be taken at face value. Now, the only thing that a judge true to the Constitution has to do is to check the validity of these provisions vis-a-vis provisions of the Constitution, vis-a-vis provisions which guarantee life and liberty, vis-a-vis judgments of the Indian Supreme Court, Indian High Courts, which mandate that all provisions which limit life and liberty should not cross or transgress the boundaries that have been set by judicial interpretation of these constitutional provisions which ensure equality, life, liberty. So I think it's not a very arduous or it's not a very complicated task. The only task is honest assessment or an honest testing of these laws vis-a-vis these fundamental constitutional provisions. That's all that is required.
Yes, and that's the only challenge is that will the courts do it? And that's a question I asked. I know is very difficult to answer, but that also prompted a very despairing question that's come up on the chat, asking that
Nadim
is
is
this
here,
now new?
Lara.
Is this?
Please
Yeah, I got
take
it. I got it.
Nadim and then get on to the question.
Yes.
He wants you to repeat the question.
Yes, I will do that. He messaged me. Yes. So, so I think a very despairing, question that came after that do we now consider then that, the political atmosphere, dictating the application of these laws and delivery of these rights, is that, become the new jurisprudence now, so that it's a question that's come up on the chat. And I think that's a really despairing situation we're seeing right now, but we have to push the limits and we have to test the courts and we have to make them also do their job rightly. So I think that is something, that accountability is something that, we do have a role to play in to deliver. Coming to Nadim is back on our discussion. And there was a question to you, Nadim, which had come in early on the chat, कि ये उच्च न्यायालय भी अभी सरकार के दबाव में ऊपर से आए हुए आदेश सिर्फ पढ़ रही है और न्याय की गुंजाइश नहीं रही। क्या हम जस्टिस गवाई से संपर्क करने का सोच सकते हैं? तो आई थिंक एक क्वेश्चन जो पूछा जा रहा है कि इसके बारे में क्या किया जा सकता है अगर एक एग्जीक्यूटिव इंटरफियरेंस जैसे दिखाई दे रहा है कोर्ट के ऊपर, क्या सीजेआई को पिटिशन करना या कुछ और वे से इसको रेज करना, क्या ये तरीका पॉसिबल है? ये क्वेश्चन आपको आया है नदीम। Can you unmute yourself?
मेरे ख्याल से ये क्वेश्चन का जवाब अगर लॉयर्स पूछे तो ज्यादा बेहतर है, लेकिन अभी अगर जस्टिस ये सारे इस ये पूरा केस पिछले जिस दिन से ये ऑर्डर आया है 1 वीक से पूरे
नदीम,
डिस्कशन है।
नदीम, आपकी आवाज ठीक तरह से नहीं आ रही।
1 सेकंड कर रहा है। आई थिंक इट्स बेटर नाउ।
मच बेटर।
इट्स बेटर नाउ।
यस।
हाँ, तो मैं ये कह रहा था कि लॉयर्स जो इस केस को देख रहे हैं वो इसके बारे में ज्यादा बेहतर बता सकते हैं, लेकिन जहां तक जस्टिस गवई का ताल्लुक है तो पूरे 1 वीक से ये केस पूरे डिस्कशन में है। अब सुप्रीम कोर्ट में जो शर्जील के लॉयर्स हैं अहमद इब्राहिम, उनके जरिए और उनके सीनियर्स के जरिए ये बेल फाइल हो चुकी है। तो बेल फाइल हुई है तो जाहिर सी बात है कि अब हमको ये उम्मीद जस्टिस गवई से है कि वो ये काम नहीं करेंगे जो काम इससे पहले चीफ जस्टिस कर चुके थे, और उन्होंने रोस्टर के हिसाब से ऐसा सेट कर दिया था कि कोई भी बेल ऑर्डर बेला त्रिवेदी के कोर्ट में जा रहा था। वी आर एक्सपेक्टिंग कि जो इससे पहले सीजीआई का मामला था कि जो उनको पुण्य करना होता था वो अपने पास रखते थे और जो पाप कराना होता था वो बेला त्रिवेदी को दे देते थे। अगर हमें उस लेवल पर एक्सपेक्टेशन है तो कोर्ट में ऑलरेडी ये मैटर बेल के लिए फाइल हो चुके हैं, इमीडिएट हियरिंग हो और सीजीआई खुद इसकी हियरिंग करें, ये हम एक्सपेक्ट कर रहे हैं। रेस्ट अब उस पे टेक्निकलिटीज पे क्या बात हो सकती है वो लॉयर अगर डिस्कस करेंगे, दैट विल बी मच मोर बेटर।
ठीक है, थैंक यू। आई थिंक ये एक लीगल स्ट्रैटेजी की बात है, तो वो जैसे लॉयर्स डिस्कस करेंगे उसके हिसाब से इस पे किया जाएगा, लेकिन ये सारी चीजें सोची जा रही है। एक और जो क्वेश्चन आया है वो गौतम के लिए, अभी एक क्वेश्चन चैट पे आया है। गौतम, इफ यू आर स्टिल अराउंड, how much do you think the order can be related to appointment to the HCs by the collegium? So,
because it's so non-transparent, one doesn't know what the inputs are and what precisely the role of the executive is, because it's all behind the scenes. So it's impossible to tell what exactly the role is. The executive has an input that we know. They themselves say it, but what it is, we don't really know because it's all opaque.
Right, right. So, before I'm going to proceed to Mihir, of course, for the concluding remarks. But before that, there was this one important question that that I need to ask. There's a question that has come up on Justice Chandrachud's recent assertion that Umar Khalid and his counsels are responsible for the trial's delay. I think some of these things have already come up during the session, but if any of the speakers would like to respond to this in particular.
Yeah, I want to. Yeah, I'll be happy to respond, because in my blog post on Chief Justice Chandrachud's retirement, I had written about this, because the thing is that, look, judges have an ideology, a judicial ideology. Every judge has one, and that ideology informs the way you adjudicate cases. Some judges have a very pro-executive judicial ideology. I'm not talking about political ideology. I'm not talking about politics. I'm saying, as a judge, some judges believe that they should be deferential to the executive on matters of criminal law, and some judges believe that they should not be. And when something as bail, which is so subjective and depends so much on an individual judge's perception of a first look at the evidence, obviously judicial ideology and just the way that as a judge you perceive legitimacy of executive arguments will play a very big role in deciding that case. And that's something that in itself is something that every court has. The US Supreme Court, the UK Supreme Court, every Supreme Court judges are well known to have ideologies about how to decide cases. Now, in India, because you have the Supreme Court of 34 judges, many of whom have different judicial ideologies and different, approaches to cases, when the Chief Justice assigns a case, then often that, indicates a likelihood of which way the case will go, especially in a matter like bail, where this plays a big role. So therefore, when these cases were allocated to Justice Bela Trivedi, who it is perceived as a judge believed that in matters of criminal law, a judge should be very deferential to the executive. Now, when you combine that with the difficulties of getting bail in the UAPA, then that would obviously mean that with a judge like Justice Trivedi, it would be very, very, very difficult, if not impossible, to get bail. And therefore, given that the discretion of the Chief Justice is in deciding whom to send these cases to, it is at that point when that discretion is exercised that it becomes very, indicative of which way the outcome will go. So in that case, and given that amount of discretion, it is perfectly legitimate legal strategy then to say, okay, the Chief Justice exercised his choice in assigning the case to a judge who is deferential to the executive in criminal law. Therefore, the lawyers then make a choice to withdraw that case. So it's I mean, this is the way that it goes, and I think that it's important to be very clear about that and very transparent about that, and not hide behind just implications. This is the way it went, and this is why the bail case was withdrawn. And just to stress once again, judges having an ideology, a judicial ideology which informs the judgments, is something that is every human being has that, and so that is nothing wrong with that. The issue is the Chief Justice having the power, the opaque and unilateral power to decide whom to send the case to, which then has an effect on the outcomes. I think that is really what we need to be talking about, not Justice Bela Trivedi, not her, but this Chief Justice's power to send these cases, which then impacts the way that they will go, and then has all these downstream effects. That's the problem.
Yes, yes, and especially in the context that the trial has not started even till date. So again, coming now to the last part of our session today, and this is on the strategies for what we can do as citizens in the campaign for the release of those who have been accused in the Delhi riots conspiracy case. And I would like to invite Mihir. Mihir, if you can unmute yourself and address us first with your what you believe would be the concluding remarks from this very rich discussion that we've seen today, and also to provide us some kind of a course as to what can be done. There are some comments that have also come on group, which talk about suggestions that on things that should be done, like writing letters to the Chief Justice, raising this issue of discrimination in implementation of UAPA. A concerted campaign that can be, organized for the release. But please, Mihir, if you can address us. Can you unmute yourself, Mihir? Manvi or Aishwarya, can you all please make Mihir co-host? Manvi, can you make Mihir co-host, please? Mihir, can you unmute yourself now?
Yeah, thanks. Thanks. I'm sorry. You'll have to bear with some noise because some people in our locality forgot to immerse the Ganpati yesterday, which was a Visurgin day. So they are doing it today. Yeah. So I'm sorry for the noise, which will also curtail me from speaking too much to your advantage. Now, what I think it was an excellent session which we had today with a lot of people. Now, all the speakers, I think, did. Can you hear me, or can you only hear the noise? Can you hear me? Lara, can you hear me?
We can hear you. You are a little faint. We can hear you, but you are a little faint. I think it's because of your AirPods. But yeah, if you can come closer and speak, maybe. Also.
Okay, can you hear me now?
Yes, better.
Okay. So I think it was an excellent session today. All the speakers spoke very well. So the question, only one or two observations which I want to make, and then I go into what I suggest can be the campaign methods and mechanisms. What Gautam also talked about, namely this whole question of the Supreme Court getting into this jurisprudence of don't treat this as a precedent. Okay. Now, this they did in Devangna's case, etc. They don't treat the Delhi High Court decision as a precedent. And if they had not said that, and this I was present virtually when this happened, and they said it without any arguments. Yeah, I mean, it is not as if after a long-winded argument, the court came to the conclusion it should not be declared. Just said it
Mihir,
without
I'm
any
sorry to
arguments.
interrupt. Mihir, I'm sorry to interrupt.
Yeah.
But there is a problem in your sound. If you can go off your AirPods and just try to, we'll bear with the background.
Just 1 minute. Just 1 minute. I've taken it off. How do I speak direct? What the teacher will do? Give me a second.
Lara, why don't you begin the discussion till Meher about the National Action Day that we were proposing, till Meher rejoins?
Sure. So I think some very important suggestions have also come on the group, and we were also proposing that there needs to be a sort of a campaign plan or an agenda that can be drawn up in order to make the demand for the release of those who have been accused in the Delhi riots conspiracy case and who have been denied bail. One of the things that has been proposed is to have a national day of action on this, where on which day we can organize simultaneous protests and also a campaign online for the release of those who have been incarcerated in the case, and also for the withdrawal of the case. So this is a call that we can issue collectively as organizations, as activists, as civil society members. And this is one of the suggestions that had come from the PUCL membership. Apart from that, there have been suggestions in the group for parcha to be drawn up on providing an explainer on the Delhi riots conspiracy case. I think there is a lot of material that is already available, but maybe an updated parcha can actually be put out, and we can spread it far and wide, and also create social media materials so that people are made aware of what is happening, and also provide them information about how the cases are proceeding. So that can be one of the things that comes in. Mihir, if you are ready.
Yeah, can you hear me? Can you hear me now?
Yes, we can hear you very well now, Mihir.
Very good. I've gone into my kitchen away from all the places.
Thank you, Dan.
See, what I was saying was this culture of don't treat this as a precedent. If the judgment had been treated as a precedent, had been allowed to continue, had not been interfered with at the initial stage by the Supreme Court, most of the others would have got bail by now. That's one thing. Similar thing happened when these bomb blasts accused in Bombay, okay, were acquitted. They were fortunate that they had been released by the time the matter went to Supreme Court. The Supreme Court didn't direct the rearrest, just as they did not direct rearrest of Devangana and others. But again, said that it will not be treated as a precedent. Why? I mean, it's a reasoned order. Like, for instance, Bombay bomb blast order is 700-page reasoned order. Why? On what basis you are saying it should not be treated as a prisoner? Just because Mr. Tushar Mehta says so. I mean, that's what has happened. That's what is happening. So that's one thing. The other thing which I wanted to just highlight is that even if you see under POTA, okay, which was the immediate precursor to UAPA's anti-terror provisions, okay, the stringent provisions of bail were applicable only for the first year. They were not applicable after the first year of incarceration. Okay, after first year of incarceration, you have the normal bail provisions. That is what POTA provided. UAPA does away with that. So in UAPA, till the end of the trial, you continue to be governed by the provisions which are stringent concerning bail. Third thing, even in respect of the releasing people because of long incarceration, Article 21 argument, what was said with Delhi High Court judgment, very, very important, was that you don't need to wait for 5 years to decide that the trial is going to take long. In the first year itself, in the first 6 months, you know that there are some 300, 400, 800 witnesses. This is the kind of situation where the trial is bound to take long time. So, but what is happening now with courts, even when they release people after on the basis that long incarceration, incarceration, it's only after 5 years, 4 years that they go into that issue. Well, what the Delhi High Court said, which is very important, that in the very first year, you can make out that this trial is going to take long. So you release them on the basis of, speedy trial not being given to you. So these are some observations I wanted to make, which I think we need to bear in mind. Apart from that, as far as the strategies are concerned, just two things I wanted to say. The legal strategy is concerned. Obviously, they will have to go to, they have gone to Supreme Court. Some of them have already approached the Supreme Court, and I guess the balance will go to the Supreme Court. And their lawyers will be the best advised to tell them what legal strategies to adopt. But it's important that we keep the campaign going. And what we need to discuss much more is about the campaign strategy. Should we, and campaign can include writing a letter to the CJI, writing, keeping this issue alive as much as possible. Keeping this alive as much as possible in the public eye, writing repeatedly about it, writing critical pieces about it, talking about it. Like today's thing is one method by which we can, continue with this campaign. So, various ways, bring out critiques of this judgment in different forums, circulate those critics, send those critics to the judges. There is no harm in sending critics of judgments to the judges. Judges themselves say you can criticize the judgments, but not the judges. Okay, you criticize the judgment and send it to them. But I think it's important that we keep the pressure on. Well, that's the only thing, because judges sitting there don't realize many of them do realize, some of them don't realize what are the actual ground level situation. So that's one thing. Second thing I wanted to say that yes, it's true. It's true that as far as the Delhi riot cases are concerned, the accused who are in jail are all Muslims. But, the basic agenda of the government is, yes, primarily Muslims, but also anybody who dissents. Whether it's Muslim, Hindu, Dalit, tribal, anybody who dissents, they are using this law against. So we have to, so while carrying out a campaign for, releasing these people on bail, we should also carry out a campaign, which basically opposes UAPA itself. It's not enough to say that these people should be released on bail, etc. That's important. But I think it's also important to talk about repeal of UAPA, which is equally important. And I think we should do that. So combine the attack on dissent, combine the long incarceration, combine the fact that laws like UAPA per se are draconian, per se are violative of fundamental rights. I think that is the way in which we can go ahead and we can continue, and this needs to be continued in a very, very strong way. It should be part of our everyday protests. That's all I can say. Thank you very much, Lara. You carry on.
Thank you, Mihir. I think some very important points. The repeal UAPA campaign needs to be strengthened. PUCL has also been, part of the Repeal UAPA campaign, and so have several organizations from civil society. And what can we do to now, with this Delhi riots case, orders also providing us an opportunity. What can we do now in order to raise many of these issues that have been a problem, not just in this case, but we've seen, for instance, in the Bhima Koregaon case, there was a point which was raised by, Harshit, on how there was a denial of the principle of, the half term, where, 5 years have lapsed since the arrest of several of those who have been arrested in the Delhi riots conspiracy case, and the rule was not applied by the courts. We are seeing today in Bhima Koregaon case also, several of the accused, Jyoti, Ramesh, are on the 5-year mark, and Mahesh Raut, in spite of getting bail, has not been released. So we have several other such instances where UAPA's draconian nature has been revealed. Bhima Koregaon case being an example. So what can we do to consolidate this campaign and demand the repeal of UAPA? I think that is a very important point that has emerged here. And how do we widen this campaign to involve the public? I think that's, again, a very important thing. What we are seeing here, the way in which the courts have been denying the right to bail is a matter of concern for the public. The manner in which this is being done, where where people have been kept in jail without any evidence, it should be a matter of concern for the public. The way in which the protests have been criminalized, or people from a community have been targeted, I think, again, should be a matter of concern for the public. So how do we talk about these things in the public domain and try and get the public also involved in our campaign is very important, because we have seen that all of these cases, as a point that I wanted to make, is that all of these cases we have seen has actually accompanied, has been along with a very vicious media trial. There has been a vilification of those who have been accused in these cases, just by putting the charge under UAPA, calling them anti-national. Again, there has been a attempt to delegitimize and also to tarnish the credibility, the reputation of those who have been arrested in these cases. And that has worked to their advantage in dominating or in coloring the public narrative. So how can we, also expose the way in which the law has been weaponized to the public is a very important question. And how do we also counter this narrative? At the end of the day, what were the people who were arrested in the Delhi riots conspiracy case doing? They were exercising their right to protest, and they've been punished, and they've made an example by the state. And to a lot of people now, it's becoming more evident. How do we take it to the those who this reality is not reached? I think that is a very important task that we all have. So on all of these things, Kavita, if you'd also like to join in on any of the points, we'll be closing the meeting now, but there have been very important suggestions that have come in. What can we do to now come together and collectively do this? How do we get this campaign together?
So since the discussion was brilliant, it was so good, all our speakers, and it was really good to see so many young people, being involved in this discussion. And I think जब तक ये चर्चाएं युवा लोगों के बीच में नहीं होगी और मानस वहां नहीं बदलेगा, तो आगे हम बहुत ज्यादा दूर तक जा नहीं सकते। युवा वकील इतनी सफाई से सोच रहे, इतने साफ सुथरे ढंग से और इतनी रैडिकली सोच रहे, बहुत वाकई में बहुत ही अच्छा लगा। मुझे लगता है लारा, हम लोगों को अगले संडे एक एवरीबॉडी लीव योर ईमेल एड्रेसेस, अगले संडे एक स्ट्रैटेजी मीटिंग कर लेनी चाहिए, बिकॉज अगर हमें कुछ एक नेशनल कैंपेन, बिकॉज दिस इज अ कैंपेन फॉर जुडिशियल अकाउंटेबिलिटी, it is a campaign where the right to bail we have to restore. If we are not going to get that restored, then actually people will only, jail has become the rule and it will be confirmed. So that has to be challenged. A campaign to restore bail is the rule, and jail the exception, that kind of campaign. तो क्योंकि वक्त बहुत ज्यादा हो गया, अभी सामूहिक चर्चा नहीं हो सकती, ये 2-3 बातों पर हम अगर अगले संडे मिल लें, और जितने भी लोगों को हम जिस तरह के हमने आपको नेटवर्क के जरिए आगे से आगे तक सूचना पहुंचाई है, इस तरीके से अगर हम एक बार और अगले संडे जूम के लिए मिल लेते हैं, तब तक ये सारी हम लोग नेशनल एक्शन डे इसको लेके, और वो किसी भी तरीके का किसी भी स्वरूप का हो सकता है, आज हम कुछ भी अनाउंस कर लें और उसको अडॉप्ट ना करें सारी संस्थाएं, तो एक मानस, सामूहिक मानस देश भर में, we have to build a national consensus in the country that this campaign will begin with a National Action Day, which may mean some sort of public action, which may mean some sort of delegation work, which may mean writing letters to the Chief Justice. So I think, Lara, we should conclude. We really have overshot all time, and we will put out another link for next week. The same time, perhaps evening is always better. And thank you so much. Please conclude.
Please leave behind your email addresses. We'll keep the chat box open for the next 5 minutes, but we can stop the YouTube